Senate Committee on Criminal Justice come to order. Clerk, call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
So a quorum has not been established yet, and we'll call members as they arrive this morning. There are a number of committees in play this morning, so there'll be folks who'll be coming in and out, but we'll do our best to conduct our business as efficiently as we can. So members of the public, improving Texas criminal justice system is at the heart of our agenda today. From testing of evidence in capital cases to modernizing the expunction process for criminal arrest records, to restitution and compensation to allow human trafficking victims to have forced tattoos removed. Add to that forward-looking changes to the Department of Criminal Justice that were recommended by the Sunset Advisory Commission, new tools for law enforcement and prosecutors to curb the growing theft of copper and brass, new rules for reviewing parole and serious crime offenders and less lethal force by police, and enhanced penalties for thieves who steal gasoline, crude oil, and oil field equipment. So these bills are here to making Texas a better and safer place to live and work, and that's our goal. That's our primary goal of this committee. It is the intent of the chair to lay out the bills one at a time, take invited and public testimony, then vote on each bill if we have a quorum in order of presentation. So if you intend to provide verbal testimony or would like to register a position on one or more bills, please register in one of the kiosks that are located behind the committee hearing room. Testimony will be limited to invited testimony and public testimony. And public testimony will be limited to 2 minutes and will be strictly enforced or as directed by the chair. So members, does anyone have any statement you wish to make before we proceed, the senators? Chair Huffman, anything you want to say?
No.
All right.
Thanks for asking, though.
But I know you will.
I usually have something to say, but I'll try to look at the behavior.
So the chair calls out Senate Bill 1870. And the chair sends up committee substitute for Senate Bill 1870. Is there any objection to adopting the committee substitute for Senate Bill 1870? Hearing none, so ordered. Recognize Senator Perry to explain the bill.
Thank you, Mr. Chairman and members. Past few years, several local governments have adopted policy and ordinances that are designed to decriminalize controlled substances or instruct law enforcement prosecutors not to enforce our state drug laws. Senate Bill 1870 prohibits local governments from adopting policies, ordinances that attempt to decriminalize drugs. If the local government violates this bill, a citizen may report the violation to an AG office. The bill authorizes AG to seek a $25,000 civil penalty for the first violation, $50,000 penalty for the subsequent violation. Mr. Chairman, there was a committee sub, and it clarifies that governments must comply with state drug laws, removes the requirement to comply with federal laws because federal laws are extremely broad, and the state is allowed to regulate drugs more strictly than federal government. So.
Thank you, members. I please show Senator Parker present. Senator Hinojosa.
Thank you, Mr. Chairman. Yeah, I agree with the bill, but it's somewhat ironic that we have passed legislation in the legislature where we instruct and give the state the right to not obey or comply with federal laws that we feel that are not constitutional.
Right.
And yet we put this restrictions on our local governments. I agree with the bill. I'm just saying it's somewhat ironic, in some of the legislation that we consider.
Yes, sir.
Any other questions? Any other questions? So chair now opens for invited testimony. Are there any? There are no invited witnesses. The chair now opens for public testimony. And there's no one registered on the bill to speak for the bill publicly, Senator Perry. So is there anyone present to speak on, for, or against Senate Bill 1870? Hearing none, we will pen the bill till we get a quorum. Yes.
This one is
We have
pending.
a quorum. Yep, we have a quorum. Our quorum is established. So if you want to vote it out, we can vote.
That's up to y'all, sir.
So the chair moves that Senate Bill 1870 do not pass, but that the committee substitute for Senate Bill 1870 be adopted in lieu thereof and be reported to the full Senate with the recommendation that it do pass favorably and be printed. Clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes, 0 nays. Committee substitute for Senate Bill 1870 will be reported to the full Senate with a favorable recommendation. You wish to go to local? Senator Huffman moves that Committee substitute Senate Bill 1870 go to local and uncontested. Any objections? Hearing none, so ordered.
Mr. Chair, I did have 1727 last time we laid it
And
out, but y'all
yes.
didn't.
Well,
It's pending.
Chair now calls up Senate Bill 1727 as a matter of pending business.
We did lay out the committee sub last time. It just changed the ledge council draft to the formal draft, or the E&E drafts to the formal. So just,
Yes. What was 1727, Senator Hinojosa?
it's the TDJJD assault bill. Just ledge council.
So we recognize that we adopt the committee substitute. So there's any objections to adoption? Hearing none, so ordered. I recognize Senator Perry to explain the difference between the committee substitute and the bill that's filed.
All it does is make the draft the official ledge council draft. In its first state, it was just the draft. So just converts it to ledge council.
Any questions? Any questions for the senator? So with that, we'll move, the chair moves that Senate Bill 1727 do not pass, but that the committee substitute for Senate Bill 1727 be adopted in lieu thereof and be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 4 ayes, no nays.
There be 4 ayes, 0 nays. Committee substitute for Senate Bill 1727 be reported to the full Senate with a favorable recommendation. Do you wish this bill to be, or you want to go to the floor
Local's
with it?
good unless there's anybody that want to talk about it.
You want to go to the floor? We can go to the floor with
All
it. Well,
Local's good. All right, thank you, sir.
well, Senator Hinojosa moves that committee substitute for Senate Bill 1727 be recommended for local and uncontested. Any objection? Hearing none, so ordered. So we're gonna go to you next. And then after that, we'll kill mine, and then that way I will have the gavel for the rest of it. Is that okay?
That's perfect, Mr. Chairman.
'Cause we've got a full day. Year 1506? Is that your sunset bill? Two 405. Chair lays out Senate Bill 2405. The chair sends up committee substitute for Senate Bill 2405. Is there any objection to adopting committee substitute for Senate Bill 2405? Hearing none, so ordered. Recognize Senator Parker to explain the bill.
Good morning, Mr. Chairman and members. Thanks for the opportunity to come before you and lay out Senate Bill 2445 and its substitute for your consideration.
2405.
2405 for your consideration as a substitute. Before I begin, I want to express my heartfelt thanks to Eric Beverly and the entire Sunset staff for their very thorough review and tireless work in evaluating TDCJ. They've been a pleasure to work with. Their detailed analysis and commitment to strengthen the Texas Department of Criminal Justice, the Board of Pardons and Paroles, the Windham School District, and the Correctional Managed Care Committee have been critical to crafting this bill and addressing the areas of improvement identified throughout the sunset process. As you know, TDCJ is currently undergoing sunset review. The Sunset Advisory Commission identified several key areas in which our criminal justice agencies and the entities working alongside them can better meet the needs of both offenders and public safety here in the great state of Texas. The committee's substitute for 2405 addresses these recommendations by continuing TDCJ, modernizing its functions, and strengthening partnerships with the Board of Pardons and Paroles, the Windham School District, and the Correctional Managed Healthcare Committee. First, the legislation recognizes that TDCJ is grappling with very serious staffing and facility challenges. We must ensure appropriate staffing levels to maintain safety and security, and do so with a long-range outlook. Accordingly, the committee substitute to 2405 requires TDCJ to develop a 10-year facilities and staffing plan. Secondly, the bill focuses on improved rehabilitation and reentry support. It directs TDCJ to maintain a comprehensive inventory of programs encompassing peer-led, volunteer, faith-based, and evidence-informed services, and to evaluate their effectiveness. The Windham School District is also given a greater role in administering post-secondary education programs, which can help inmates gain the skills they need to reenter our communities in a productive fashion. TDCJ and Windham will jointly develop a strategic plan to eliminate program delivery bottlenecks and prioritize inmates waiting for parole-voted programs. This promotes a common-sense shift toward more efficient programming, reduced recidivism, and increased public safety. And members, this prioritization should result in $150 million in savings over the next 5 years. Third, we address the Board of Pardons and Paroles by enhancing consistency and fairness in its decision-making processes, particularly around imposing special parole condition and granting release on medically recommended intensive supervision. Through the rules and ongoing training, the board will strengthen accountability. It will enhance transparency in how special conditions are applied and better coordinate with TDCJ to reduce inefficiencies that impact supervision and public safety alike. Fourth, the Correctional Managed Healthcare Committee will continue to develop and approve healthcare plans for inmates. This legislation primarily aligns that committee's statutes with standard sunset language to ensure its continued effectiveness. And finally, this committee substitute for 2405, in comparison to the original filed bill, makes a number of non-substantial cleanup changes to TDCJ's governing statute requested by the agency. It modifies the long-term facilities and staffing plan to allow for more flexibility and reduce duplication of efforts. It codifies recommendations of the Office of the Inspector General. It also codifies TDCJ Rider 26, and it includes compensatory time updates to incentivize officer retention. Members, this committee substitute to 2405 ultimately reflects a commitment to public safety, to operational efficiency, and the successful rehabilitation of inmates in Texas. It keeps TDCJ in place while addressing staffing and modernization issues. It clarifies the roles of our agencies, and it ensures that our parole process is as consistent and transparent as possible. I want to thank you so much for your time and consideration. I want to, again, thank the committee staff. I want to thank everyone that's taken this through, supported us through the sunset process, all the stakeholders. I know we've got some incredible witnesses today from Sunset and TCJ and so forth, a lot of incredible experts. Happy to answer questions, Mr. Chairman, but again, appreciate the opportunity to come before the committee and lay out this bill here this morning.
Thank you, Mr. Vice Chairman. Senator Hinojosa.
Thank you, Mr. Chairman, and thank you for all your hard work, Senator Parker. I served with the Sunset Commission before. I know how much the staff works to make the changes necessary and update our different state agencies. But I do have actually one question. If you look at the LBB, analysis, it says, as a result of this bill, there will be a restriction upon the open records law and the access to government information. Do you know what they're talking about?
I'm really going to defer that to the Sunset Commission to be able to respond specifically on that, Senator, if that's possible.
Okay, not a problem.
We went through extensive preparation on the bill and gone line by line, but I think they can give you the best information and insight on that particular question.
Well, that comes from the LBB staff.
Sure, sure.
So, thank you, Mr. Chairman.
Any other questions, senators? Questions? Do we have testimony?
Yeah, let's bring Sunset up.
What? So- So do we have a representative from Sunset Commission present? Invited testimony, could you please step forward and state your name, who you work for, and be prepared to answer some questions? And if you would, you've asked, please register after you're done.
There we go.
State your name, where you work for, and
Good morning.
Here's-
Darren McDivitt, Sunset Commission staff. I'm the project manager for the Sunset Review of TDCJ, Board of Pardons and Paroles Correctional Managed Healthcare Committee in the Wyndham School District. And that is the review, of course, that produced the bill that's in front of you today. Senator Hinojosa, would you repeat your question, please? I was in the back, sir.
Senator Hinojosa recognized.
Madam Chairman? Yes.
Recognized.
There's an open government impact statement on Senate Bill 2405. And it has, as a result of this bill, there will be a restriction upon the open records law and the access to government information. That's from the LBB staff, GMC and DRE. That's the initials. I'm just trying to figure out what it is.
Mr. Chairman, let me ask a question. Where in
Yes,
the
Senator.
bill are you reading from, Senator Hinojosa?
At the end of the bill, there's a one-pager that talks about the open government impact statement by the LBB towards the end. It's the last page.
Oh, are you looking at the fiscal notes?
You looking at the fiscal?
Are you looking at the bill or where are we looking? Sorry.
No, I'm not looking at the bill.
Okay, where are you? You are?
I'm looking at the Legislative Budget Board's open government impact statement. I can pass it on, Madam Chair, so you can.
Members, there are a couple reports that are required as part of this bill. I'm flipping through the committee sub to try and find that specific reference, sir. But just to speak in generalities, and why don't I go back through the bill and provide the information in writing to y'all with the committee, just to make sure I'm giving you accurate info, because I'm trying to flip through the bill and find that provision. But through the course of the sunset process, one of the discussions was about the reporting and the information that TDCJ does in terms of long-term facilities planning, but also in their work with the Board of Pardons and Paroles regarding reporting surrounding medical requirements and medical information for inmates. There are some exemptions to the Public Information Act for those reports, the documents, the work products that are produced by the agencies with those provisions. But what I would like to do, sir, is go back through the bill and make sure that I'm giving you the right information with regards to what the fiscal note is referencing.
That's fine. I was just asking because the LBB wrote the statement, so I'm trying to figure out what they were
Yes,
talking about.
yes,
'cause
sir.
They didn't give an explanation.
Yes, sir.
Mr. Chairman, I think they're required by law to do that, but again, I don't know. We could always ask LBB to come. You could ask them. That would be my only suggestion.
Okay. Thank you, Mr. Chairman.
Thank you.
Thank you, sir.
Thank you. Any other questions, members? Senator Parker, you recognize.
Thank you, Mr. Chairman. Appreciate all the great work that you've done throughout the process. You know, one of the things that's very unique about Sunset, aside from all the process modifications and so forth, is the ability to really find opportunities for savings. And I'm particularly excited about the fact that I've shared in the layout here this morning that we have roughly $150 million of savings that we've been able to find through restructuring, if you will, of process. I just wanted to ask you if you would mind giving a recap for the members as well as the public with regard to how we're getting to that number, how we're getting to 150, what's taking place, and basically how we derive that figure. That would be, I think, beneficial for everybody this morning.
Of course. So again, members, as the project manager, we took a look, as the project manager of the review took a look at rehabilitation programming. And so that is what we're speaking to in this area. Rehabilitation programming, meaning the programs by which inmates are required to go through as part of their process for seeking parole and going through the parole review process by BPP. And there are a lot of different groups involved with that. So TDCJ provides programming, the Wyndham School District provides programming, and some of the programming is contingent upon the parole vote. So BPP approves somebody for parole, and if they complete that last program, they're considered good to go if they successfully complete that program. So what we found during the review is that those different entities could be more aligned and work together to create a strategic plan. I believe, Vice Chair Parker, you mentioned that in your layout. And what we also found was that the parole-voted programs, they do have lengthy placement timelines. So the Board of Pardons and Paroles already does work with TDCJ to account for a reasonable amount of time that it takes to get somebody into programming, finding bed space at a different prison. If it's a small program, waiting for a spot to open up in that program. But what we found is that some insufficient strategic planning does drive lengthy program placement timelines beyond that reasonable period of time that they already account for. So they already build in what we call a buffer, and then it is taking them a bit of time beyond that buffer to find placement programs, even though they've already accounted for sort of a reasonable logistics time. That, of course, has a cost. So when you look at the LBB's cost per day, that is the most expensive part of the system, is somebody being incarcerated. And again, this is folks waiting for programming. The BPP has already said, if you complete this program, we're going to consider you ready to go home. And those days add up where people are waiting around, waiting for a bed, waiting for space. So we had recommendations that Vice Chair Parker laid out that would require the agencies to work together to create a strategic plan and reduce those program placement timelines by 50% starting in 2027. So that's where the LBB fiscal note addresses those issues, and I hope I addressed your question, sir.
That was perfect. Thank you for giving a detailed analysis and overview of what we're doing and how we're achieving those savings. That was very beneficial.
Also shows Senator Hagenbu is present, and Senator Hagenbu, you're recognized.
The question, Mr. Chair, is to follow that up. So that's great. The overall improvement and then the cost savings on top of it, outstanding. And you said that the cost savings are from a reduction in the days required. Does that mean there is a personnel reduction then, or how did the actual savings take place?
Mostly that's just driving from being driven by folks spending less time incarcerated. They would, those days, that cost per day, per individual, that's where we made those calculations.
Good. Thank you very much. Appreciate it. Thanks.
Thank you. Any other questions? Any other questions? Thank you.
Thank you for the great work you all done. Thank you very much.
Thank you.
Chair now opens up for public testimony. So the chair calls the following witnesses: Brian Collier, Christina Hartman, Marcia Moberly, and Luis Soberon. So Luis Soberon. So we'll begin on my right and state your name, who you represent, and your position.
Good morning, Chair, Vice Chair, and members. I'm Christina Hartman, Superintendent with the Wyndham School District, and I'm here as a resource today and also here to thank you all for your efforts in a process that was quite positive for our school district. So thank you very much.
Any questions? Go ahead.
Good morning, Chairman, members. I'm Brian Collier, Executive Director of the Texas Department of Criminal Justice. Here's a resource. Thank you.
Thank you.
Good morning, Chair Flores, Vice Chair Parker, Marcia Moberly with BPP. Here is a resource.
Any questions? There's no questions for you, so thank you very well. You have a question?
Yeah.
Senator Parker. So, what, are you Mr. Soberon?
Yes, sir.
Okay, you've got your 2 minutes.
Good morning, Mr. Chair and members. My name is Luis Soberon. I am a Senior Policy Advisor with Texas 2036. Here for the bill, I'm going to focus exclusively on the post-secondary programs that are offered within the Texas Department of Criminal Justice and now through Wyndham School District. We released a report last year. Catch my breath, I had to kind of run in here. We released a report last year that looked into how post-secondary programs were offered in TDCJ, and we found that over the past 10 years, there's been about a 50% enrollment decline. And one of the contributing factors to that is a severe governance and coordination problem. The Sunset staff report recognized as much, and we are really supportive and grateful for the new role that's contemplated by Wyndham School District, and we're grateful for the inclusion in the bill for provisions that relate to evaluation, data collection, data governance of post-secondary programs, and codifying the parole provisions that relate to the post-secondary education reimbursement program. We think that there could be a little bit more in setting the post-secondary programs on a firmer legal and policy footing, but we really think that this bill represents an incredible step forward in how we offer post-secondary programs for incarcerated Texans. So thank you. Happy to answer questions if you have them.
Mayor Parker?
Thank you, Mr. Chairman. Appreciate all of you being here very much. Director Collier, thank you for your leadership and for being here. I want to come back to the question I asked earlier a moment ago about the folks of the Sunset Commission about the savings that we're obviously achieving in the bill. Obviously, savings are secondary to public safety. Public safety is all that matters in the end, but it's nice that we can find some savings as well. I just wanted you to comment on that topic for a moment with regard to the savings we found. And that these are individuals that have already been cleared, so to speak, in the process, ready to return to the free world once they finish the programming. Just wanted to get your perspective on that and commentary, if you wouldn't mind, Director.
Betcha. Thank you. And Vice Chair, if I could, I'd just like to say thank you to the Sunset Commission. We worked very well with them. They were a great group, and we appreciate all the effort that they went through, and appreciate your effort in carrying the bill and working with us throughout this process. So greatly appreciate that.
My honor.
During the sunset process, they identified, as we had individuals who had been voted for parole but had a requirement to complete a program, that there were delays in about 40% of the time getting those individuals into the program in a timely manner, which would have essentially caused their release to occur what we would consider on their date set by the parole board. So we had people essentially finishing programs after their desired completion date because they were not getting into the program when they should have. The Sunset, as the Sunset did the review, their goal is for us to, or their requirement is for us to drop that by half by August of '27. We intend to do that sooner, but we're working. We have done several internal modifications to try to improve the efficiency of that process so that when someone's voted for a program, based upon the date given by the parole board, the placement in that program is very quick and would get them enrolled and moving quickly so that their release can essentially occur. As to the savings, we're essentially getting people through this process. We would have people that essentially get out on time versus being delayed in their release, which does equate to a savings because our system is growing. It likely will prevent us from maybe having to engage beds that we have offline sooner by being able to keep those beds empty based on keeping that timeline in check.
Thank you very much. And then, what are your thoughts on how that impacts ultimately your facilities footprint? Just get your thoughts on that as well.
Yes, sir. So the Sunset Bill is we will be doing a study of all our facilities and doing a 10-year plan to identify needs. And when we look at the 10-year plan, you're looking at facilities, what those needs are at those facilities, the staffing availability for those locations, but also looking down the road. For instance, in a biennium, we need several hundred more infirmary beds. Almost every biennium, we have to add and modify beds to make that happen. So having a 10-year projected plan on what that population need is going to be so that we're ahead of that before it gets here, as well as the LBB projections would be part of that overall plan that we would work on.
Very good. Thank you very much,
Yes, sir.
Director Collier.
Thank you. Any more questions? Thank you all very much.
Thank you all for being here. Appreciate you very much. Thanks for the great work.
Any more public witness? Chair now calls Cole Meyer, Alexa Garza, and Kirsten Budwine. Cole Meyer, Alexa Garza, and Kirsten Budwine.
Here I am.
Yeah, you're here. Thank you for being here.
Yes, sir.
So I'm just going to do it one more time. Cole Meyer, Alexa Garza, and Kirsten Budwine. Are you Cole Meyer? All right, you have the floor. We'll begin with you, and thank you for being here. And please, you have 2 minutes, and your name, who you represent, and your position on the bill.
Yes, my name is Alexa Garza. I am for Ed Trust in Texas, and we are on for the bill. Thank you. Honorable Chair Flores and members of the Senate Criminal Justice Committee, thank you for the opportunity to speak today on SB 2405. I serve as a Texas policy analyst for Ed Trust. I am a system-impacted woman who obtained my associate's and bachelor's degree while serving 19 years flat in the Texas Department of Criminal Justice. Higher education has profoundly impacted my life by equipping me with the knowledge and skills and confidence to overcome challenges, broaden my perspectives, and pursue opportunities that were once beyond my reach. Most recently, I earned my master's degree in business from Texas Women's. While we appreciate SB 2405, which includes improved data sharing and evaluation for post-secondary programs within TDC, we urge the committee to enact the statutory transfer of admin and management of these programs to Wyndham through an MOU with TDC rather than relying solely on a budget rider. In 1999, when I first began taking college classes, Wyndham oversaw higher ed in prison. There was a college counselor on the unit. Class schedules were designed to provide ample access and opportunity for every student, and every classroom in the education building was utilized. However, in 2011, administration of higher ed shifted to TDCJ's Rehabilitation and Programs Division. Post-secondary education was under the broader umbrella of chaplaincy, recreation, volunteer services. The once bustling halls became quiet, the college counselors went away, and classes dwindled to just one a week, marking a stark decline in educational offerings and access. As time went on, out of the 644 ladies at the Mount View unit, there was 9 of us actively enrolled in higher ed. What I witnessed firsthand is supported by the data. Since the transfer of admin from Wyndham to TDC in 2011, post-secondary enrollment and credential completion has declined by nearly 50%.
Thank you for your testimony. Thank you for everything you've done to improve your life, and it's
Thank you,
very
sir.
nice. Senator Parker.
Thank you for being here, and appreciate very much you testifying before the committee, and congratulations on your degree and all the success you're having in life. I just wanted to clarify that the transfer to Wyndham is in fact codified
Awesome.
here in the bill. So just wanted to clarify so that we haven't addressed that in the substitute.
Thank you. I had a chance to peruse it, sir. Thank you so much.
Thank you. Thank you for being here.
Am I good to go?
Yes, you're good to go.
Perfect. My name is Cole Meyer. I'm with Texas Appleseed, and I am on the bill. I believe I registered in support initially, but I'd like to correct that if I didn't put it as on.
Okay.
Just wanted to clarify that. Alrighty. SB 2405 makes a concerted effort to move TDCJ towards data-driven rehabilitative programming and more efficient administrative processes, both of which would allow for a safer and healthier environment within TDCJ. And while we endorse these recommendations put forth in the bill, there's still a couple improvements we think could be made to ensure the department meets its goals. I've provided y'all with a fact sheet and a markup of the Sunset Bill with our recommendations, which includes requiring collaboration with external researchers and requiring TDCJ to report on the criminogenic needs of its population when evaluating programs, amongst many other things. But for today's testimony, I'd like to focus on post-secondary education. To start, Wyndham School District has a strong track record of collecting and analyzing data in the realm of education, and so knowing that, we do support the transfer of post-secondary from TDCJ to Wyndham, and I'm glad to hear that it's in the committee substitute. Number 2, we recommend adding language to Wyndham's biennial evaluations to include post-secondary education, and we recommend adding language that allows Wyndham to collect data on its students applying for occupational licensure prior to release. And lastly, we recommend amending the data sharing language for Wyndham to reflect data sharing agreements instead of MOUs, so they're stronger. And we recommend expanding this list to include more state agencies, not just the Higher Ed Coordinating Board. Sharing with other entities like TDLR and TWC would maximize access to relevant workforce, academic, and post-release data. And again, I'm not sure, I haven't seen the committee substitute yet, so I'm not sure what is addressed in that, but I'm glad to hear that some great changes have already been made. But to close, higher education and data collection can improve outcomes in our justice system. We hope you incorporate these recommendations, and I'm here to answer any questions that you have.
Thank you. Thank you for your
Thanks so much.
testimony.
Thank you for being here.
Budwine. Morning.
Hello, Chair and members of the committee. My name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project, here speaking on SB 2405. I've sent Senator Parker, your office, some of our detailed recommendations, so today is only like a piece of this. I first want to say that we appreciate all the work that the bill authors, Sunset staff, and the Sunset Commission has done to suggest reforms around TDCJ and the Board of Pardons and Paroles, and also all the work that you've done to put these adopted recommendations into a bill. We do believe that more reforms around the Board of Pardons and Paroles discretion should be implemented to get us to a point where more elderly and sick people are released on medically recommended intensive supervision. The Sunset Report found that the MRIS panel, which is a branch of the Board of Pardons and Paroles, does not adhere to BPP's own voting policies. Voters routinely consider factors outside of the two considerations that are allowed by statute and policy. While the bill itself does require the MRIS panel members to go through extensive and substantial trainings on MRIS guidelines, we believe that people who are sick and elderly will continue to be declined release because of this threat to public safety consideration that BPP must consider in its calculations on whether to release someone or not. This is why we recommend instituting new guidelines requiring the Board of Pardons and Paroles to start from a presumption of release under MRIS if an individual meets the statutory criteria, unless the panel finds by clear and convincing evidence that the individual poses a risk to public safety that cannot be mitigated while under the supervision of the Pardons and Paroles Division, and require that the BPP MRIS voters undergo training. That part is already addressed in the bill, so thank you.
Thank you, Senator Parker. Any questions? Thank you all for being here.
Thank you.
Thank you very much for the good feedback along the way as well. Thank you.
So seeing no one else registered for public testimony, is anyone present wish to testify on, for, or against Committee Substitute for Senate Bill 2405? Hearing none, public testimony is closed.
Make a comment.
You want to? What was that? Senator Parker.
Thank you, Mr. Chairman. Senator Hinojosa, you asked a question earlier this morning from the LBB. I don't think we have an LBB person here yet, but I want to just kind of tell you what I think is happening there. They believe that the statement basically is referring or triggered by the provision in the bill that allows for MRIS medical evaluators' information to be redacted. So that's just an issue pertaining to really the medical record, so to speak, for those individuals that are in that program at that time in our care.
Medical records ought to be exempt, but thank you for your explanation.
That's my understanding. We'll get further follow-up from LBB, but I think that's the issue. But again, I don't think there's any way for us to address that in any other way. So thank you.
Thank you.
You ready to vote it out? Senator Huffman?
Yeah, I'm sorry, Senator Parker, to sort of ask you this last minute, but just been reading this carefully and listening to your layout. This is kind of a general question, and the reason I ask this is because, you know, sunset bills, you can't amend on the floor or anything.
Yeah.
So I want to make sure we get this right before it gets out of here, right?
Yes.
So I just want to make sure with all these recommendations, different, you know, changes that you're making about the parole guidelines, is there anything in this bill that requires a parole board or a member to vote a certain way once certain criteria is established, and take away the discretion from parole board to make the ultimate decision about whether or not an inmate should be released?
Senator, thank you for the question. Absolutely not. There's nothing that restricts that in any way.
And you're certain of that? 'Cause I'm sort of reading through this. It's starting, you're leaning towards this with requiring, like, looking at the different 3-voter parole panels, you know, regionally throughout the state, to make them look at how the other one is voting and compare that. And I'm wondering why we're taking that next step if we're not moving towards, and that's always been my concern, that you take away the discretion, because a lot of times in these files, there are things that, you know, it may objectively look one way, but once the parole board digs in, maybe a certain horrific crime, or the victims are still very involved in contacting the parole board. I mean, there are reasons sometimes why parole members make decisions. I see some nodding heads, even from, Senator Hinojosa, I think, agrees.
Yes.
And I just want to make sure, and there has been a movement to go towards these guidelines and go towards requirements of having to parole, when certain, measurements are there. And I think someone testified to that. So I just want to make sure this bill is not, and that is not your legislative intent.
That is correct. And so we, I think we've found the right structure, but again, maintaining discretion is critical. So
Okay.
we're on the same page, and
All right.
that's certainly legislative intent. That's what we've tried to do here in the draft, and so I think we've fulfilled that.
Okay, thank you, sir.
Thank you for the question.
Yes.
We have no amendments, so there's no amendments present from members?
We're not aware of any.
Any amendments from members before we move this? Because once we get out, there's no more amendments, correct?
It's it. Can't do anything.
Are you ready to vote?
I am, if you all are. If you want to stay, come back.
You ready to
I'll
vote?
just have a couple hours, before the end of the day, like we voted today, but just give me a little bit of time.
You want to suspend it?
Yeah, but not past today, I don't want to mess up this bill, yeah.
Everyone voted out?
Let's hold it for a couple little, maybe we'll do it on the floor or something later today.
Yep, we'll leave committee substitute for Senate Bill 2405 pending. We'll leave it pending. It's pending.
Okay.
Let's get your water. Well, the chair recognizes Senate Bill 1804 by Senator Alvarado. So the chair recognizes Senator Alvarado to explain the bill.
Good morning, Mr. Chairman and members. Senate Bill 1804 supports the recovery of survivors of human trafficking by making it clear that courts can order restitution to cover the cost of tattoo removal in cases where the tattoos were applied through force, fraud, or coercion. Current law allows courts to order payment for medical and mental health treatment, but the law does not contemplate tattoo removal. For many survivors, these tattoos are physical reminders of the trauma that they experienced, often branding them with the trafficker's name or symbols. The bill updates the law to ensure that survivors are not left to pay for these costs by adding tattoo removal to the list of eligible restitution expenses under Article 42.0372 of the Code of Criminal Procedure. Senate Bill 1804 also removes the age restriction in current law, so adult survivors, not just minors, can receive restitution for these specific costs. The Attorney General's office oversees the Crime Victims Compensation Program, which administers existing reimbursements for survivors. This program has existing detailed review processes to verify criminal conduct, document injuries, and documentation, payment, or loss. The OAG has confirmed that they will implement rules and procedures to handle requests for tattoo removal in the same way they currently process other crime-related reimbursements. Mr. Chairman, I know you and I had some conversations, and we both had the same thought when this bill was brought to me by the OAG's office, to make sure you can confirm that this tattoo was involving human trafficking, and they do have a very stringent process that they go to make sure that it is legitimate. And they do have a witness here. I don't know where they are, but they can answer any questions in terms of the process for that application for restitution.
Thank you, Senator. And yes, and thank you very much for addressing that, and that there was a process, and to make sure that there were. This is a terrible thing that's being done to women, where they're being branded like their property by these traffickers, and so we want to make sure that they're treated adequately by Texas. And thank you for this bill. Any questions? Thank you, Senator. So Chair now calls Brody Burks. Please state your name, who you represent.
Good morning, Chair, Senators. My name is Brody Burks. I'm a prosecutor with the Human Trafficking Division at the Texas Attorney General. I'm here to answer any questions. I know we also have some people directly from our Crime Victims Compensation Unit as well that can answer some of those technical questions. But just as a preliminary matter, I want to talk to you a little bit about what we are seeing here. It is extraordinarily common that we see tattooing, branding, other marks of ownership being applied to our victims. Over this last summer, I actually tried a case where that had been done to a 15-year-old girl. We ended up bringing in some of our investigators to talk about what those tattoos were, how they linked them to the defendant in that case. In that case, he was actually putting matching tattoos related to the Aryan Brotherhood of Texas that he had and putting tattoos on her to match that. So we see tattooing like that. We also see tattooing of the trafficker's name, very specific ownership marking. So that is something that we are seeing in a lot of these cases. I know one of the questions was, how do we verify that? So in cases where there is a trial, we have trial transcripts, we have affidavits by the trial attorneys, we can verify it that way. And in other cases, we will submit offense reports, investigative reports that link the tattooing to the human trafficking from the investigators who are working that case on the front end. Happy to answer any questions that you have.
Any questions to Senator Parker?
No questions. Mr. Chairman, I just want to thank you for what you're doing on the front lines and prosecuting these monsters. Thank you for what you're doing and the good work at the AG's office. Thank you very much.
Thank you.
Thank you. Thank you for coming. There's no invite. There's no public. So the chair now opens for public testimony. We're seeing as no one has signed up to testify on this bill. Is there anyone present who wishes to testify on, for, or against Senate Bill 1804? Hearing none, public testimony is closed. So we'll vote this out. Please, Senator Parker.
Senator Alvarado, thank you for bringing this bill. I think it's so important on numerous levels. We've been in this fight to stop human trafficking for a number of years here in Texas, and we're proud Texans. We've done a great job, I think, in fighting it, but we're still about the worst you can be in terms of offenders. And I think this is a very, very important piece of legislation because at the end of the day, if these victims, if they don't have the psychological health to be able to really be restored, to go through that process of healing, to go from being victim to survivor. Unless you have this type of thing, it's a constant reminder of what they went through physically in front of them every day. Unless it's removed, it's gonna absolutely thwart the process of healing and going from victim to survivor. Do you agree with that?
Absolutely, and this has always been an issue that we've come together in a very bipartisan way. Both chambers, we've done a lot to tackle human trafficking, but it seems like there's always something that we're discovering that is left to do. And I know Senator Huffman, she's also worked a lot in this area. So this is just another piece. Maybe it helps to bring those victims some peace of mind, some closure, some comfort, and be able to move on and have a productive life.
I think it's a very important piece of legislation. Thank you for bringing it forward today.
So the chair moves that Senate Bill 1804 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Aye. Senator Miles? Senator King? Senator Hagenbu? Aye. 5 ayes, no nays.
There'll be 5 ayes and 0 nays. Senate Bill 1804 will be reported to the full Senate with a favorable recommendation. Senator Alvarado, you wish this bill to be recommended for local? Yes, Senator Parker recommends that Senate Bill 1804 be recommended for the local uncontested calendar. Is there objection? Hearing none, so ordered.
All right, I think I was thinking knocking mine out that way. The Senate Parker's the lead. I've got the gavel for the rest of the day. So
So we're gonna go ahead and knock mine out, so the clock has to leave. I got the gavel ready. Well, you know what? Let's knock mine out, that way I can have the gavel. And if you have to leave. You were 1099.
The chair lays out Senate Bill 1099. The chair sends up the committee substitute for Senate Bill 1099. Is there an objection to adopting the committee substitute for SB 1099? Hearing none, it's so ordered. I recognize Senator Flores now to explain his good bill.
So thank you, Mr. Chairman, members. So members, the crisis at the border has caused increases in crime throughout the state, and citizens and non-citizens often face the same punishment for equal crimes. Senate Bill 1099 addresses the issue of criminal offenses committed by illegal or unauthorized aliens by increasing the penalties for such offenses. Specifically, the bill amends existing laws to ensure that if a defendant is found to be an illegal or unauthorized alien at the time of committing a felony offense, the punishment is elevated to the next highest category of offense. And I have a committee substitute to make it clear that this bill is only to be applicable to unauthorized aliens who are illegally present at the time of their offense. Senate Bill 1099 amends Chapter 42 of the Code of Criminal Procedure by adding Article 42.01992. This new article establishes a requirement for the judge to make an affirmative finding of fact if it is determined beyond a reasonable doubt that the defendant was an illegal alien at the time of the offense. This finding must be entered into judgment of the case. The bill amends the penal code by adding section 12.503. This new section specifies that an affirmative finding under Article 42.01992 is made at the trial of a felony. Now, mind this, that what we're targeting here is the felonies that are 3G offenses. That's murder, that's kidnapping, that's trafficking, that's sexual offenses, aggravated robbery, other than a capital felony, since that's the maximum crime, that the punishment for the offense is increased to the punishment prescribed to the next highest category of an offense. If the offense is punishable as a felony of the first degree, the minimum term of imprisonment is increased to 15 years unless another provision of law provides for a longer minimum term. The legislative change is intended to act as a deterrent and to ensure that the legal consequences for illegal aliens committing crimes are more severe, reflecting the state's stance on maintaining public safety and legal order. Senate Bill 1099 will protect all Texans and ensure they are not receiving unbalanced justice. So the intent here is going after the 3G offenses. So they're here under the premise of illegality in the first place, and this is a land of opportunity, but we're targeting the people that take our state and our citizens as an opportunity to prey upon and commit 3G offenses, which is happening in increasing ways throughout our state. So they're here illegal. We're not talking about someone who's being stopped for a traffic offense, Senator Hinojosa or Senator Hagenbuch, someone for a minor. We're talking about 3G offenses that are really affecting our communities. They come here to prey upon us, these individuals that we're targeting in this bill. And so if they want to stay here a little longer, we've got a TDCJ, which they get to stay a little longer. But the main thing is we want to provide a deterrent that the premise of being here illegal and acting and doing heinous acts upon our citizens with the impunity in their mind is being addressed. That's the intent of this bill. And for any questions.
Thank you, Mr. Chairman, for the excellent layout. And Senator Hinojosa has a question.
Senator Hinojosa, yes.
Just clarification, Mr. Chairman. On the 3G offenses, right now the minimum is 5 years.
We have to confirm that, but if that's, it varies. It varies. And the 3G
Very.
offenses, yes.
Okay, so a first-degree felony doesn't, I thought it was a first-degree felony had a minimum of 5 years.
And the charge with murder, kidnapping,
Correct.
sexual offense, that's the varying factor on the degree of the crime.
And most of the time, once someone that is in this country illegally or undocumented, after they serve their sentence, they are deported.
Well, that is our hope that that's done. So yes, we hope that happens. But for the purpose of this bill is that those that are here with the premise of preying upon us.
No, I understand that, and I think there is a practice, not hope. There is a practice that somebody at TDCJ and is serving time for let's say 10 years or the 15-year minimum, as you set out in this bill, they will get deported. TDCJ does not release those people out into the community. So
that is our intent.
Thank you.
And again, we're targeting the very criminal component that commits these 3G offenses upon our citizens. That is what we're targeting. So, Senator Miles is present.
Will the record please show that Senator Miles is now present? Members, are there any further questions at this time of Senator Flores' bill? Okay, very good. We'll now move on to invited testimony.
Colonel Freeman Martin.
And we've got Colonel Freeman Martin to come forward here this morning. Colonel, it's great to see you. Thank you for all you do every day for all of us. So grateful to have you in committee this morning. If you wouldn't mind just stating your name and affiliation and position on the bill for the record.
Chairman, Vice Chair, Freeman Martin, the Director Colonel of the Texas Department of Public Safety, and I'm here as a resource witness on the bill, neutral on the bill.
Very good. Thank you, Colonel. Members, are there questions at this time of the Colonel?
Just,
Please.
So
Senator?
thank you for being here, because this bill is also as a result of our conversations that we've had. So could you please explain to the committee some of the examples of that we were discussing as we talked about the genesis of this bill?
I could actually, when you called, we're talking about an unrelated crime, but we're dealing with several others at the same time. And over the last 4 years, there were 114,000 migrants who are here with illegal status that were booked into Texas jails. At the time we had the conversation, over 11,000 of them had active warrants, Texas-based warrants. Sure. So of the 114,000 migrants with illegal status that were booked into Texas jails over the last 4 years, over 11,000 had active warrants. And at the time of our conversation, we were dealing with the situation in Bastrop County where an individual was driving on the wrong side of the road while intoxicated, struck the rear end of a Cadillac and veered in oncoming traffic and struck a Chevrolet pickup. The subject and the victim in the Chevrolet pickup ultimately died, and there were hundreds of people showed up at the hospital that night. He was an icon in Bastrop County. People demanded answers. How did this happen? The subject was here illegally, had been previously deported twice, had DWIs out of the state of Kansas, and it kind of sparked this conversation where we really started digging into some of these cases. So last night, when I was asked to come testify this morning, I asked the chief of the Texas Highway Patrol, the chief of Criminal Investigations Division, and the chief of the Texas Rangers to send me some examples. I couldn't even print them all out this morning. There are so many cases: capital murder, rape, robbery. There's some drug offenses that would pertain to this, 3G offenses, all with migrants who are here with the illegal status. So, really our goal is not to run up a bunch of numbers in how many people we can arrest. It's the absence of crime. And this is a deterrent for criminal aliens to not commit crimes in Texas. What happens is what we do, not what we say. And they know that if they commit minor offenses in Travis County, they can be in and out of jail every day. But at some point, it's got to rise to the level when they commit these type of offenses, that we hold them accountable for their actions, and the federal government now is doing their part in the deportation part. But so that's really a conversation that we had, and I didn't realize that you were going to file the bill, but
Never know.
it's definitely a deterrent. Yes, sir.
Never know. Very good.
Thank you, Colonel.
Members, are there any further questions of the Colonel? Thank you, sir, for all you do. Very grateful. Thanks for the great testimony.
Thank you.
Okay, that will conclude our invited testimony here on the Senate, substitute rather, for Senate Bill 1099. And so we'll go ahead and close invited testimony. And now we'll move to public testimony. And the chair would like to call forward the following individuals: Crystal Gomez and Daniel Woodard. Thank you both very much for being here. If you wouldn't mind stating your name and your official title and position on the bill for the record, we'd be most grateful this morning. Thank you for being here.
Thank you. My name is Crystal Gomez, and I'm testifying on SB 1099. I'm with Texas Immigration Law Council in the Texas chapter of the American Immigration Lawyers Association. So as an immigration attorney with extensive experience in this field, I have to express concerns about the bill's definition of illegal alien and its broader implications for the Texas criminal justice system. SB 1099 employs a fundamentally flawed definition that mirrors what we'll see later in SB 552, broadly categorizing as illegal aliens individuals who either entered without inspection or who failed to maintain non-immigrant status. And this oversimplification contradicts the nuanced reality of immigration law. Many individuals who technically fit that description on paper actually have lawful presence now, including DACA recipients, TPS holders, asylum applicants with pending cases, and survivors of domestic violence or trafficking with humanitarian applications in process. So while this bill attempts to address the previous concerns by adding a third prong with the committee substitute and excluding those who have not attained and maintained legal status before the offense, this language still fundamentally misunderstands how federal immigration law works. It's not binary or static. Somebody having immigration status will exist on a spectrum and will change based on case by case and how policies change and what administration's in office. And these cases can remain pending for years, so you'll see a change back and forth on whether someone is presumed to have lawful status or not. And this is a concept that even immigration judges struggle with. I think I'm here to raise concerns that I'm not sure how our state judges are going to be trained in how to make these determinations when even federal judges, when this is all they do, have a hard time determining legal status under constant policy change and administration change. Thank you.
Thank you for being here. Appreciate your testimony. Sir?
Good morning. My name is Daniel Woodward, and I'm a policy attorney with the Texas Civil Rights Project, and I'm here in opposition to Senate Bill 1099 today. We oppose treating people differently based solely on their immigration status in the criminal justice system. And I think it's inappropriate to raise state criminal penalties based on immigration status because, as the person before me mentioned, immigration law is largely a civil body of law that Congress did not intend to map onto state criminal penalties. And adding time to a state crime based on immigration status is precluded by federal law because it amounts to adding punishments for federal immigration violations. In some areas of law, states are welcome to supplement federal crimes. However, immigration is an area that courts have repeatedly said is the sole prerogative of the federal government because, in part, and there are other reasons too, our nation will not have a united foreign policy if 50 states have 50 different immigration policies. Furthermore, it will be costly and time-consuming to put difficult immigration status determinations into the hands of local magistrates and judges, especially when the definition includes people who may now have lawful status or even citizenship. Federal immigration judges have years of training to make these complex determinations. It is all that they do. State and local magistrates will get bogged down hearing evidence on a matter wholly outside of their purview. And how would a busy local judge respond if a prosecutor says a person is out of status when the crime was committed, but the person comes in with proof that they are a U.S. citizen? For these reasons, we oppose SB 1099, and we urge the committee to vote no. Thank you.
Thank you for your testimony. Senator Hinojosa's question.
Thank you, Mr. Chairman. I guess for the immigration attorney, I apologize. I don't have your name on the tip of my tongue.
It's okay.
When you're charged with a crime, under the Constitution, you're required to have an attorney or an attorney appointed for you if you cannot afford one. And then you have to prove, the prosecutor has to prove beyond a reasonable doubt that you are in this country illegally. Okay? So there's those two hurdles. And then for the ACLU, you said that there was a federal law that prohibits states from enhancing immigration penalties?
I'm saying that federal immigration law imposes civil and in some certain cases criminal penalties. And immigration law is precluded from the states having their own immigration laws because it's entirely the purview of the federal government. So
I understand the concept, but
yeah.
I don't recall ever seeing a federal law or statute that prohibits a state from increasing criminal penalties for certain crimes committed by people who are in this country illegally.
I think the problem is the connection between immigration status and the raising of the bar, because you're basically putting a penalty on someone for their immigration violation.
Okay. Thank you.
Members, any further questions of our folks that are here testifying this morning? Seeing none, thank you both for being here.
Thank you.
Appreciate it very much. That will go ahead and conclude. I don't see anyone else officially here signed up. Is there anyone else wishing to testify on, for, or against the committee substitute to Senate Bill 1099? Seeing none, our public testimony is now concluded. Ready to vote?
Are we good?
Yeah.
We good? And Boris? Are we good? So are we good?
Good to vote.
Are we good to vote, or? Yeah, let's vote it out.
Make sure he knows how he's voting. Sorry, I thought I heard sorry.
Yeah, all good. The chair moves that SB 1099 do not pass, but that the committee's substitute for SB 1099 adopted in lieu thereof be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa? Senator Huffman? Senator Miles?
No.
Senator King? Senator Hagenbu? 4 ayes, 1 nay.
There being 4 ayes and 1 nay, the committee substitute for SB 1099 will be reported to the full Senate with a favorable recommendation.
2569.
The chair lays out Senate Bill 2569 and recognizes Senator Flores to explain the bill.
Thank you, Mr. Chairman, members. I appreciate your time and effort today. And so during the 83rd regular legislative session, 2013, HB 912 was signed into law, which created Chapter 423 in the Texas Government Code. House Bill 912 was introduced in response to the rapid increase in drone usage and established prohibitions, criminal penalties, and reporting requirements for law enforcement agencies. Since 2013, the technology and use of UAs has rapidly increased. DPS went from 35 reports in 2017 to now over nearly 50,000 per year. The report is so large that computers used around the legislature have a difficult time opening the file, further making the physical copy is financially burdensome and time-consuming. All Senate Bill 2569 does is modernize the reporting requirements by simply requiring LEAs to post their reports to their public-facing website. I thank you for your support and answer any questions.
Thank you, Senator Flores, for this good bill. Members, are there questions of Senator Flores this time? Seeing none, we'll go ahead and move forward with our invited testimony on Senate Bill 2569. And looks like one individual here. If I can now call forward Jason Day. Thank you, sir, for being here. If you wouldn't mind stating your name and affiliation and position on the record on the bill. Thank you very much for being here.
Yeah, Mr. Chair, committee members, good morning. My name is Jason Day. I am the Director of Unmanned Aircraft for the Texas Department of Public Safety. I'm here to testify on Senate Bill 2569. Texas DPS is neutral on the bill, and I'm happy to answer any of your questions at this time.
Appreciate you being here, sir, very much. Thank you for all you do for Texas. I think at this time we're good. Don't think we have any questions. So thank you very much for being here.
Thank you.
Seeing that we have no other invited testimony is officially closed. And we'll now move to public testimony. We have no one registered here in advance to testify on Senate Bill 2569. So is there anyone else here wishing to testify on, for, or against Senate Bill 2569? Hearing none, our public testimony will also now conclude. So I think we'll go ahead, members, and vote this good bill out. The chair moves that Senate Bill 2569 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator King? Senator Hagenbu? 5 ayes, no nays.
There being 5 ayes and 0 nays, Senate Bill 2569 will be reported to the full Senate with a favorable recommendation.
Come to local.
We'll go ahead and make a motion here to send it to the local and uncontested calendar. Senator Huffman recommends that Senate Bill 2569 be recommended for the local and uncontested calendar. Hearing any objection? No objection. It's so ordered.
There's one more. It's then 2570.
The chair lays out Senate Bill 2570. The chair also sends up the committee substitute for Senate Bill 2570. Is there any objection to adopting the committee substitute for Senate Bill 2570? Hearing none, it's so ordered. Now I would like to recognize Senator Flores to explain the bill.
Thank you, Mr. Chairman. Members, law enforcement officers are legally justified to utilize force in many situations to bring suspects to justice, to protect others, and for personal defense. Lesser levels of force are used regularly by police with great success in de-escalating dangerous situations. Less than lethal devices such as tasers, pepper spray can reduce injury rates for suspects and officers. In order to encourage our peace officers to rely on less than lethal devices, this legislation provides peace officers a defense to prosecution when using these devices when attempting to prevent harm or death to the public, officers, or suspects in dangerous situations. I do have a committee substitute. And the bill as filed was intended as a placeholder bill as we work towards a better solution with the committee substitute. And the committee substitute creates a defense to prosecution in Chapter 9 of the Penal Code if the conduct is justified. The committee substitute for Senate Bill 2570 applies to peace officers and guards employed by a correctional facility and defines less lethal force weapon as any weapon, device, or munition that is designed, made, or adapted to expel a projectile or multiple projectiles against a target to temporarily incapacitate the target while minimizing the risk of serious bodily injury or death. or a chemical dispensing device, or a device used to strike a person, or a stun gun is defined by the Texas Penal Code, Section 38.14. Members, less lethal force is justified to the degree necessary to accomplish the person's official duties if the use of the weapon is in substantial compliance with their training, with the person's training. The Senate passed a version of this bill last session, and this bill is not retroactive like the one that went out last time. So we thank you for your committed support, and I'm here to answer any questions.
Thank you, Senator Flores, for laying out the bill. And Senator Hinojosa has the first question.
Thank you, Mr. Chairman. I guess, Chairman Flores, about a week ago or so, we passed legislation dealing with charging a police officer with an offense of deadly
conduct.
Deadly conduct.
Yes.
And the legislation that Senator King had, we actually changed the presumption to, we did away with with the presumption in those type of situations, and also changed, instead of an exception, did away with the presumption to. But to me, this bill right now, and I'll hear the testimony, seems a little bit overly broad in the sense that we are giving a blanket protection. I think police officers are well trained in terms of how to use their non-lethal weapons. You have situations where we've seen where someone is tased to death just because they taste again and again and again and again. Certainly, the officer could then come and say, "Well, I reasonably believe that it was necessary to control the person, defendant." So I just expressing some of my concerns with with this bill in terms of how broad it seems to be, and I
would love to address those concerns to answer your questions. So, yes, in the discussion we had previously, had to do with the firearm. That's not that with
a non-lethal weapon.
Yeah, he's pointing a firearm, which is a lethal weapon. So this one is the non-lethal. So what we're saying with this bill is, and within the scope of their training, that's what has to be proven. So if you've got someone with a baton and they're striking someone intentionally, knowingly, repeatedly on the head, well, that's not within the scope of the training with non-lethal, for example. Or any use of a non-lethal weapon that's outside of the scope of their standard training, as you described, they go over and over and over and over again. Was that within the scope of their training? That's something that's not acceptable to use any weapon that's outside of the scope of their training. Like the training I've had in non-lethal, I use the baton. I guess I'm showing my age in my law enforcement career, but you're trained, not to intentionally strike someone in the head with that, because that could be lethal. Rather, we were trained to strike areas to bring them in compliance with what we were trying to do. As for the defense, in working with the law enforcement community, and you'll hear witnesses today to talk about that, we were looking at the different types of defenses. The defense on this particular bill is a defense to prosecution, which means that it's not saying you can't be charged. You can't. It's the defense to prosecution is something that's proven in the court to show that where the prosecutor will have to show that they did not follow their training. And so we chose the middle. Affirmative defense is the highest level. The burden's on the defense to prove and least protective of law enforcement. The exceptions to conduct, what we talked about last time, and on this one, was the highest form of protection, which this is not being used in this bill. What the law enforcement community expressed to me and what this bill intends is to choose the middle one, the defense to prosecution, which is the burden on the defense to raise, but the burden on the state to prove the case beyond a reasonable doubt. So that's where we chose that one.
Senator Flores, I guess.
Maybe I misunderstood.
I happen to be a criminal defense lawyer. I've done those cases, and I've defended a police officer for police brutality. With this bill, I can get up any police officer. I can get him off, just from my experience in a trial where that officer is accused of this offense in terms of a bodily injury or serious bodily injury or even death.
Well, it's not my intention of this bill to make it easier for someone who has not operated within the scope of their training, to be able to, get a wet ticket out. That is not the legislative intent of this bill. The intent of this bill is to show as a defense to prosecution, and I value your experience and if there's anything we can do to improve this bill, I'm willing to work with you. But it's for those that are operating within the scope of their training, and then they get prosecuted for that. That's what this bill is. That as a defense to prosecution, you're properly trained, you properly used it. But I'll say it again. This is not my intent, the legislative intent of this bill, that someone who is operating outside of the scope of their training and abusive of that use of force. That's not who we're talking about. We're talking about everyone else using non-lethal force instead of having to go straight to using a firearm and killing someone. This hopefully will encourage more use of non-lethal force than lethal force. That's the intent here.
Thank you, Chairman.
Thank you, Senator, for the question. Are there any further questions? Senator Hagenbu.
Thank you, Mr. Chairman. Senator Flores, on this, to give you a chance to explain kind of why we need this bill, how prevalent is this where you have an officer who did operate within their training with a less than lethal weapon and end up getting prosecuted for it?
Well, we can look here in the city of Austin, and where a peace officer is trying to defend his community and defend it from rioting and from imminent danger to themselves and others, and then they all get sent to grand jury, every one of them, and as if while exercising their ability to their training to serve and protect, are having to answer for every incident of use of force, and so that is the most prevalent one is here locally, but there's other cases, and I'm sure the witnesses will come forward and be able to answer more of that question.
Thank you. Thank you, Mr. Chairman.
Community.
Thank you, Senator, for the questions. Members, any further questions of Senator Flores at this time?
Just want to point out that what happened here in Austin, that they charged police officer with deadly conduct. Then it was dismissed because there was a lack of evidence to support those charges. I think they indicted 20 officers, 17 were dismissed because there was no evidence to support the charge of deadly conduct.
Yes. Thank you.
Very good. Okay, we'll go ahead now and move to invited testimony. And the chair now calls John Wilkerson. John, thank you for being here. If you wouldn't mind stating your name and your affiliation and position on the bill for the record, sir. Thank you for being here.
Good morning, Mr. Chairman. Is this on? Yes, it is. Okay.
It is. Thank you.
Yes, my name is John Wilkerson. I'm here representing the Texas Municipal Police Association. We represent nearly 35,000 peace officers, correction officers throughout the state of Texas. We're in very much support of the chairman's bill. We've worked with the chairman and his awesome staff for the past several months to perfect a language. Several law enforcement groups worked with this. We testified during the interim charge hearing on this bill, or on the topic, and what we're hopeful for the committee to understand and to take away from this is law enforcement every single day are faced with situations where they are 100% justified in using deadly force. But we remember that we put that badge and that uniform on for a reason, and that's to protect and preserve life. So if there's any way that we can avoid having to use deadly force, we want to do that. And anytime we do that, we are taking personal risk, because we know a lot of times that sidearm will stop the threat immediately. But if we can utilize less lethal force and reduce the chance of taking somebody else's life, then that's what we do, even knowing that it's going to place our life at a risk for doing so. And so we feel that it's only right and only necessary that we have some additional protection in the statute that says, hey, if the officer acted within substantial compliance with their training, they didn't do anything that was just flagrantly a violation of their rights, that they're able to enjoy this defense to prosecution, especially when faced with the situations like we saw in Travis County during the situation that Mr. Chairman Flores pointed out. So with that, again, I want to say thank you to the chairman and his wonderful staff for working with law enforcement to find some good language on this bill. And I stand ready to answer any questions.
Members, are there any questions of Mr. Wilkerson at this time? We just appreciate you being here. Thanks for all you do, protecting all of us. Thank you very much. Okay. That will conclude our invited testimony, and we will now move on now to hear public testimony. I'll now call the following 4 individuals up: James Songer, Robert Leonard, Patrick Capitillo, and Kathy Mitchell, please. Thank you all very much for being here. Appreciate it very much. And we'll go ahead and start, sir, with you here.
All right, good morning, Chair and committee members. My name is Lieutenant Matt Songer, and I am with the Dallas Police Department. I'm here to testify in support of Senate Bill 2570. We're focusing on when Taser released its new Taser Model 10, the method used to propel the prongs resulted in it being classified as a firearm underneath the Texas Penal Code definition of firearm. Our department was concerned with the possibility of officers being held criminally responsible for injury due to what is now classified as a deadly weapon, rather than a less lethal tool. We believe this bill will ease fears associated with new technology and would allow law enforcement to utilize the newest, less lethal tools. We support opportunities for expanded use of less lethal tools that result in less police deadly force incidents. Thank you for the opportunity to testify in support of this bill.
Thank you, sir. Appreciate you being here. We'll come back to any questions here once everybody speaks. Good morning.
Good morning.
Mind state your name and your affiliation and position on the bill, please, for the record.
Good morning, Mr. Chairman, members of the committee. My name is Robert Leonard. I am the Executive Director for the Combined Law Enforcement Associations of Texas, commonly referred to as CLEAT, and I'm also a retired police officer and a former prosecutor, and I am here in support of this bill. We are basically asking for your support in that this bill would go a long way to defending officers against overzealous prosecutors and district attorneys who are actually persecuting police officers for doing exactly what we train them to do. For the past 15 to 20 years, we have encouraged officers to de-escalate and to use non-lethal force. I can tell you that when I started my law enforcement career in 1986, we didn't have things such as tasers and beanbags and other devices that are now currently being marketed in order to assist officers to end confrontations with sometimes even armed and dangerous subjects in a way that would result in nobody being killed or any loss of life. However, we have, as the chairman pointed out earlier, 19 officers who were unnecessarily indicted here in Austin during the 2020 riots. They acted in accordance with their training. They utilized the equipment that they were required to use that was issued to them by their department. They followed their training, they followed the law, and they followed the lawful orders of their superiors, who basically instructed them to carry out their duties. And when they did, they were indicted and they were prosecuted for alleged crimes just for doing their jobs. And that's unacceptable. We need to offer them an opportunity to protect themselves. And I think this is important, as there was some reference made to last week's committee hearings and some other legislation. This is not a carve-out. It is not an exemption, and it is not a free pass. That is the most important thing that I think we need to get across here is, thank you.
Finish the statement, sir. Go ahead.
I think that is the most important thing that we need to get across here is that this is not letting officers off the hook for any misconduct that they may engage in. I think, as the chairman pointed out, that an officer who utilizes non-lethal equipment inappropriately or not within the course and scope of their duties or their training, there is an avenue for the district attorney's offices to pursue a prosecution in that case. However, we absolutely believe that officers need this protection that is provided to them in this bill so that we don't have a repeat of the officers who were unfairly indicted here in Austin for doing their jobs.
Thank you, sir, very much.
Mr. Chairman, I need to...
Yes. Senator Hinojosa.
I just want to point out and clarify that the issue with those police officers here in Travis County, City of Austin, there were 20 indictments and 17 were dismissed only because there was no evidence on the charges. But we addressed that issue on deadly conduct to Senator King's legislation last week, or week before last, I can't remember which week, so I lose track of time around here. So, I mean, so we're addressing that issue. I don't think it should be used as a reason why we need such a, what I consider a broad blanket piece of legislation. And I understand the situation you're talking about, but I just want to clarify the issue dealing with the 17 officers that were indicted.
May I respond, Senator?
You sure may.
But those officers, the 19 officers that were eventually, the charges were dismissed and dropped against them, spent 2 years in purgatory. They were unemployed. They struggled to provide for their families and to pay their bills. And we believe that if this law was in place at that time, it may have gone a long way to prevent the unnecessary indictment of 19 officers where the evidence clearly showed that there wasn't enough evidence to support the charges. That's why they were dismissed.
Let me point out that if the Senator King's bill legislation would be in place at that time, the indictment would not have taken place. It would not have been deadly offense. And most of the time when an officer gets suspended, they get suspended with pay. And I know the stress and pressure of somebody being under an indictment. I don't deny that. But that doesn't, to me, it doesn't. There's not a good enough reason to all of a sudden provide a blanket protection. It's just my opinion, and I know we may disagree on the approach, how to do that, but thank you for your testimony.
Thank you, Senator.
Please proceed.
Mr. Chair, members of the committee, my name is Patrick Capetillo, and I'm here on behalf of the Dallas County DA's office, and I'm testifying on this bill. I will say, in reviewing the subcommittee's substitution this morning, it's the position of the DA's office that this bill is unnecessary. I think under Chapter 9, there are already legal defenses that are available to police officers and us as citizens should they use force. And what is interesting about Chapter 9 and how it's comprised is most of the language in Chapter 9 is fairly consistent. Ultimately, when you're talking about the use of force, you're talking about whether or not an officer had a reasonable belief that his use of force was immediately necessary under the circumstances. I do have some concerns. I appreciate the intent, and I do want to provide clarity, or the DA's office does want to provide clarity to officers and to prosecutors who are handling these types of cases. I've handled them myself, dealing with less lethal devices. But I believe this is a good start. I don't know that this bill truly accomplishes the intent, and I think it might, as Senator Hinojosa had pointed out, it might have some unintended consequences because it's going to be very difficult to prosecute an officer. If I'm thinking as a criminal law practitioner, stepping inside a courtroom, it might be very difficult to prosecute an officer even if they were not acting within common sense, training, or any other method that we would think would be appropriate to judge their action. And so in our position is this bill is unnecessary. It's a good start, but I don't think it fully accomplishes the intent of the chair. Thank you.
Thank you very much for your testimony. Members, any questions? Go ahead, ma'am. Oh, sorry, Senator Hagenbu.
Yes, Mr. Capetillo, I pronounce your name? Capetillo. Thank you. Yes. But to the point that was made earlier about the officers that were here had two years where they were until they got off. How would you?
I can respond to that.
Yeah, please respond to that.
So in Dallas County, we also had cases that where officers were indicted and prosecuted for the unjustified use of force using less lethal devices. We indicted 4 officers. All 4 of those officers pled guilty to assaultive conduct, acknowledging the fact that they were acting in an unjustified manner. The system as it is today under Chapter 9, in our view, it works. If we can provide more clarity to law enforcement officers and to DA's offices, we fully appreciate that. But the system as it exists today, we believe it works.
Well, but that circumstance you just said, with this law in place, if they admitted and or proven that they worked outside their training and that kind of thing, then they still would be prosecuted, right? But I'm talking about a case where they were obviously in the end, let off, basically agreed that they didn't do anything wrong, but they spent 2 years of their lives where this would help alleviate that, right?
May I respond, Senator?
Yeah.
My position is, even if they acted outside of their training or inside of their training, in the case of the 4 officers that were indicted in Dallas County, there was some gray area in whether or not their training covered the exact conduct that they were faced with, because ultimately we're talking about an incident that doesn't happen on a regular basis when you're talking about civil unrest. And so there wasn't training that truly prepared the officer for every single situation. They were put in difficult circumstances. And of the hundreds or thousands of incidents that we reviewed of officers using less lethal weapons, there were only 4 officers that were actually indicted. There were only 4 officers that we found violated the law and acted in an unjustified manner. And for that reason, we believe that the system's already working as is.
I appreciate what you're saying, but you're talking about a different case. I was asking about the one here where there were 19 that were let off.
And I can't speak to the particulars of Travis County just purely because I don't know the details of those incidents. All I know is that certain indictments were dismissed. We had a different scenario in Dallas County.
Could I follow up with a question for Mr. Leonard? Mr. Leonard, how prevalent is this? I mean, Mr. Capetillo indicated that this is very rare, but how prevalent is it that officers prosecuted for less than lethal when, unjustly, you would say?
We're starting to see an increase in this across the state and across the country, actually. We believe that the political agenda of too many district attorneys today are not in the pursuit of justice, but into satiating the campaign promises that they made to their constituents that helped them get elected, which was that they would prosecute, although we would say persecute, police officers in the performance of their duties. And this is the problem that we're facing more and more. You have too many officers who are unjustly indicted when the district attorney's offices know that they can't prosecute these to the full extent of the law. They can't take them to trial, but they leave officers in limbo for months or years until these officers are finally at the point the case is dismissed and the charges dropped. As the gentleman next to me had stated, the situation in Dallas was where they actually believed that they could go to trial, and they resulted in the officers taking a plea deal. However, here, the 19 never, ever believed for 1 second that they were acting outside the course and scope of their duties, outside of their training, or outside the law. And again, using the equipment that was provided to them by their department and following the directives of their lawful superiors, they acted in the best interests of the public and the citizens of the city of Austin and Travis County. However, the district attorney here felt that it was necessary to indict 19 officers where ultimately we know there was no evidence of criminal action on their part.
Thank you. And quick follow-up. I understand that law enforcement agencies are having great difficulty recruiting and retaining officers. Do you think this kind of thing lends to that?
Absolutely. Why would you take a job for what we believe to be modest pay to put yourself in the crosshairs of prosecutors and district attorneys who basically are going to indict you unnecessarily for doing your job? We are just struggling to fill the seats in academies all over the state. Every department in the state is understaffed. It's even worse in the sheriff's departments, including the detention officer ranks in the jails. So if we want to save the profession, we need to implement laws like this that offer the officers a modicum of protection going out on the streets. Again, this is not a free pass. This is not a carve-out. It's not an exemption. This is basically giving the officers peace of mind, knowing that if they do everything that they're trained to do, taught to do, and that they reasonably believe that they're doing correctly, that there's a defense to the allegations or the indictments that are brought against them.
Thank you. I appreciate the answer.
Thank you, Mr. Leonard. Any more questions?
A question for the lieutenant, but I can let somebody else ask. Yeah, you talked about the tasers, the modern tasers, and did I hear you right that that's considered a lethal weapon in the law right now?
Sir, yes, sir. Basically, what we've come to the conclusion on in our legal side or DPD attorneys, the way that fires meets the definition of firearm because it uses a combustion and a primer in it, and that meets the definition of firearm.
But the very design of it was to avoid having to use a lethal weapon, right?
So there's no definition for less lethal weapon in Penal Code. So this bill would actually help define that and give us that.
Does this bill go far enough, you think, in defining the taser is not a lethal weapon?
Yes, sir, I do believe it does.
Okay. Thank you
Because
very
it
much.
defines
Thank you,
less
Mr. Chairman.
lethal.
Hi, thank you. My name is Kathy Mitchell. I'm with an organization called Equity Action. I wish to speak to similarities between the bill that you passed earlier and this one. That earlier bill, Chairman Flores, to your point, was about bullets and guns, the exception. And this is about all the other weapons. Taken together, those two bills bypass 9.51 and 9.52 and create a new standard for all uses of lethal and less than lethal force for police officers. 9.51 requires immediate necessity, as you've just heard. It also requires that before using force, the actor manifests his purpose to arrest or search and identifies himself as a peace officer. This is a critical difference. In SWAT raids, in nighttime interaction, anytime a person in Texas is facing the use of force, they have a right to have that officer identify themselves before they do that. This has been a big issue. Most cases in which officers are prosecuted for excessive force have nothing to do with the protests of 2020. Officers are prosecuted for excessive force, for slamming people's heads into the pavement, for tasing people repeatedly, to Senator Hinojosa's comment earlier. These cases are rare, but they do arise. And it is rarely, if ever, I want to read one more thing. Those are the key standards that are being bypassed by this law, 9.51, 9.52. Instead, we're creating 9.55, and the standard is going to be, it was used to the degree reasonably necessary to accomplish the duty. So we've taken immediately necessary and having previously identified as an officer, and substituting reasonably necessary to do your job. This is a broader standard. It is going to provide an enormous protection for officers in all kinds of use cases that we haven't even imagined. And I do believe that that is an unintended consequence, but I think it's real. Thank you. I am here to oppose the bill. Sorry, Chairman. And my organization is Equity Action.
Members, are there any further questions? Senator Flores.
Thank you, and I thank you all for your testimony. And we still have we have two more witnesses, but I want to thank you all for your testimony and your input. And members of the public, this is a hearing, and a hearing is where we hear what you have to say about a bill, whether it's mine or everybody else's. We get our input, and we do our best to perfect it so that it can accomplish our intent, legislative intent of this bill. So I want to thank you all for being here.
Thank you, Senators.
Thank you all very much. Appreciate all you do. Thank you. Okay, the chair now calls Alicia Castillo and Chris Harris to come forward, please. Appreciate you being here, sir. Go ahead and state your name and your affiliation and position, please, for the record.
Sure. Thank you very much for having me. This morning, my name is Chris Harris. I'm here with the Texas Civil Rights Project, and we are in opposition to the bill. So firstly, I want to just reflect my remarks to some of the falsehoods that continue to persist about the indictments that occurred here in Austin by the Travis County District Attorney and why they were ultimately dropped. They were dropped because evidence was presented by the management within the Austin Police Department that the weapons that they had given to officers, the less lethal shotgun rounds specifically, were defective. That they had, in management, had not been tracking the expiration date of these devices, and therefore they had found prior to the protests in 2020 that these weapons were causing undue harm when used on members of the public. However, they had not addressed this issue prior to those protests. Those weapons were subsequently given to officers. Now, they were not lawfully ordered to wantonly fire tens of thousands of rounds into mostly peaceful protesters. Nonetheless, the district attorney dropped these charges when evidence was presented by management conveniently immediately following the statute of limitations for their own criminality, prevented them from being indicted for allowing these weapons to be used. Nonetheless, that evidence was presented to the district attorney. Subsequently, he dropped the charges because clearly the injuries that had been sustained by many of the people, many of the victims, were not intended because the weapons were defective, right? So, the system, in many ways, worked as intended. When presented with new evidence, the charges were dropped. Now, I think the big question is Austin Police Management. Nonetheless, to my remarks, if the goal of this legislature is to decrease the use of lethal force and increase alternative means of dealing with situations, the answer is not to decrease the standards for the justified use of less lethal weapons. It's to increase the standards for the justified use of lethal weapons. Making it more difficult to use lethal weapons encourages not only the use of less lethal weapons, but also the thing that all of us want, which is more and more de-escalation of situations without the use of force to begin with. And so what we're seeing, unfortunately, with this committee sub is that we're going backwards. We're now not only lowering these standards, we're allowing you to ignore the manufacturer's instructions. We're allowing you to ignore agency policy. This green lights unlimited use of force with these weapons, which do cause real harm, can cause real harm to people, permanent damage and even death in, manufacturers say, is up to 3% of cases. So it is really, really important that we continue to strengthen the standards for use of force, strengthen the standards for law enforcement, and ensure that we have a system that holds everyone accountable justly to the law. Thank you.
Thank you very much for your testimony. Members, are there any questions this time? Appreciate you being here. Thank you very much. I want to call again, make sure it's not here, Alicia Castillo. Okay. Is there anyone else here wishing to testify on, for, or against the committee substitute to Senate Bill 2570? Hearing none, our testimony was officially closed.
So, Mr. Chairman, so if I may, may I request that we leave this bill pending so I can work with my colleague, Senator Hinojosa, and his expertise, and with law enforcement to make sure we get exactly what we all can get a good perfecting of this bill so that we can move it forward. So I recommend to pen this bill.
Mr. Chairman, sounds like a good plan. And so the committee will officially keep the committee substitute to Senate Bill 2570 pending here in committee at this time.
Thank you. Chair now calls Senate Bill 1667 by Senator Zaffarini. So the chair lays out Senate Bill 1667. So you're recognized.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1667 relates to the procedures for the expunction of arrest records and files. It is the companion to House Bill 3733 by Representative Angela Orr. Members, when a person petitions for his or her criminal record to be expunged, the district clerk must send notices of an expunction to law enforcement entities, court officials, and DPS. This process is costly and time-consuming, especially when physically mailing the notices, because not all agencies receive them electronically and some receive duplicates. Relatedly, county fees for mailing expunctions vary, and multiple DPS departments may receive separate notices about the expunction, creating redundancy and further increasing costs. What's more, current law limits the retention of expunction orders to a period starting from the 6th day after the order was issued and ending no later than 1 year after issuance. Expunged criminal history, however, sometimes remains accessible online beyond this period. As a result, persons who lose or misplace their original expulsion orders often return to the clerk's office after the retention period expires to request a copy, only to find it is no longer available, thereby requiring them to restart the expulsion process. Senate Bill 1667, which was requested by the County Clerk and District Clerks Association, would modernize the expulsion process in our state by reducing mailing costs, improving efficiency, and providing petitioners continued access to expulsion records. Generally, it would first require a person eligible for expulsion to provide the court the necessary details for the court to process the request. Establish that expulsion petitions cannot list a state or local agency more than once. Require state and local agencies to accept electronic service whenever possible. Establish a standardized $25 fee per entity when electronic service is not available. Include the Office of Court Administration as an entity who receives a copy of the final expulsion order, and require clerks to retain expulsion orders indefinitely and to provide a copy to the person subject to the order who presents proper identification. Mr. Chairman, there is a committee substitute.
Chair sends up committee substitute for Senate Bill 1667. Is there objection? Hearing none, the committee substitute adopted. Please explain the substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, the committee substitute was requested by the Office of Court Administration and the County and District Clerks Association and differs from the bill as filed in that it would first require the clerk to maintain in a confidential manner or mental health order for a criminal case if the order is related to an expulsion order. And that's all it does.
Any questions for Dean Zaffarini? Any questions? Chair now opens up for invited testimony. Chair calls Patty Henry.
Good morning, Chairman Flores, committee
How are you?
members. Thank you, Senator Zaffarini, for presenting this bill. Currently, when someone files a petition for an expunction, they are charged $350 for the filing fee. Then they must pay $15 per agency listed in the petition. And that can be anywhere from 12 to 30 agencies, depending on how detailed they get. So at 12 agencies, that's an additional $180 to file so that we can send all that paper. This bill eliminates those costs. If we can get an email address from the agency, we can send it for free electronically. And the clerk will be listing the local agencies and the state agencies that you would normally list in an expunction. We would have that on our website, so it's there for them to copy onto their petition, therefore saving them money. We're also going to repeal, there's a $1 fee per agency for each notice and a $2 fee for each order to each agency that we're also repealing in this bill. The main part of this bill is the order. All these laws were written when we were all paper. And in this world of electronic everything is on the internet and it lives so much longer. And there have been so many instances, especially in my county, where people come to me 2, 3, 4 years after an expunction was issued and they have something showing up on their credit report. They have something showing up when they're trying to get housing, when they're trying to get a job, and we don't have the order to give them. They haven't kept the order, or they've lost it, or their attorney, although in a perfect world, the attorneys or the pro se litigants should keep it forever locked in a vault. That's just not the reality of the world that we're in. They need the order again, and they've already paid the money. It's just a shame that the information would live so much longer in our electronic world, but we would not give them access to the order that could clear their name without making them pay another $350. The Clerks Association has been working on this for a while, and we're very thankful to have worked with DPS, the OCA, Texas Criminal Defense Lawyers Association, Texas District and County Attorneys Association, Alliance for Safety and Justice, Texas Appleseed, and the Texas Public Policy Foundation on this bill. In addition, what we found out recently, thankfully with the OCA's help, is our mental health orders. That has been a shining light this session on mental health commitments. And we realize that when you have a criminal case that has a mental health order in it, currently it's being obliterated. The order is being obliterated. So even though it's been reported to NICS, if NICS goes back and does an audit and they find that DPS does not have the order and the clerk doesn't have the order, they must remove that entry from NICS, which is a big problem. So we're very happy to solve that issue, to find that issue and to solve it in this bill by not only retaining the order of expunction, but also in those cases, the mental health orders.
Thank you. Thank
And
you.
I'm here for any questions.
Members, any questions? Senator Hagan? Thank you. Thank you for being here. And tell
You're
everybody back in Anahuac hello.
Thank you.
Thank you.
That closes, there's no one else for invited testimony. It closes invited testimony. Well, the chair now opens for public testimony. Do we have any? So the chair calls Paul Quincy. Paul Quincy. I hope I pronounced that correctly, sir.
Yes, sir. Thank you, Mr. Chairman.
State your name, your position, who you represent, and your position on the bill. You have 2 minutes.
Thank you, sir. My name is Paul Quincy. I'm an attorney here in Austin, and I'm testifying on Senate Bill 1667 in my private capacity. I've been practicing expunction law for about 20 years, a little over 20 years, and I'm hoping to serve as a resource witness to give perspective of the people who need this relief the most. I thank Senator Zaffirini very much and her staff for working with me and considering my suggestions earlier this week. I currently work full-time as a reference attorney at the Travis County Law Library. Our director, Lisa Rush, has developed our library into a self-help center for pro se litigants, assisting for people with things like uncontested family law matters, special needs driver's licenses, and my part is helping innocent people clear their good names. Expunction is only for innocent people. People who have been arrested but never charged with any crime, or whose cases have been dismissed, or have been acquitted at trial, come to me every day explaining how these records operate to prevent them from seeking advancement in their education, seeking housing, gaining employment, and the psychological toll of simply having an arrest record can take. These are people who have never been and will never be found guilty in a court of law, and to this day remain presumed innocent. But the existence of an arrest record means much of society still treats them like criminals. It's incredibly rewarding work, and working with people who usually can't afford a lawyer to represent them, I've learned how the impacts of arrest records are often the harshest on the people who can least afford it. I thank Senator Zaffirini for bringing this bill that seeks to solve two problems that my patrons would face in dealing with this process on their own. Which agencies to notify of the expunction, and what happens when their information is reported by third-party data aggregators, even after having been expunged. Senator Zaffarini's thoughtful 21st century approach to expunction service, requiring that it be done electronically unless there's good reason not to, will greatly facilitate the processing of these orders and get people out from under the specter of a false criminal allegation more quickly. I would suggest adding a provision that clarifies that the custodian of records for each agency is responsible for complying with the orders and requiring their emails to be published on the clerk's website as the bill envisions. Unfortunately, once the arrest information, however false or misleading, is released into the public sphere, there's no getting it back. Even though these third-party data aggregators like PeopleSearch and BeenVerified.com
Thank you for
are
your
required-
testimony.
Is that two?
Thank you. When you hear the beep, that's it.
Okay.
But thank you very much.
Thank y'all.
The bill's in good shape. So seeing no more public witnesses, is there anyone here wishes to testify on, for, or against committee substitute for Senate Bill 1667? Are you registered to just? What is your name? Fill out the registration card and come, please take a seat. State your name, your organization, who you represent, and your position.
Okay. Thank you, Mr. Chairman. My name is Amanda Marzullo. I am the policy director for the Austin Community Law Center. We provide free and low-cost legal services to people here in Austin. Again, I'd like to thank Senator Zaffarini for this bill. We think it's very necessary, but we do have a concern about keeping the order in these cases. That is something that could get out, could expose people within the court system to criminal liability for releasing it. We think a more practical solution in this case would be to require third parties to revise their records when they're inconsistent with the newly expunged arrest record. So we think that essentially it's creating another problem instead of providing a solution. It would make more sense to have people correct their records based on the information that's available after the expunction. And we've been working with Senator Zaffarini and her staff. We're really hopeful that we can address this issue while the bill is still in committee. Thank you.
Thank you. Any questions? Senator Zaffarini, your light's on?
No, it's my bill.
Yeah, do you want to respond to it? Nope. Okay. Well, thank you. There's no one else registered for public testimony. Anyone wish to testify on, for, or against committee substitute for Senate Bill 1667? Hearing none, public testimony is closed. The chair moves that Senate Bill 1667 do not pass, but that committee substitute for Senate Bill 1667 be adopted in lieu of thereof. It be reported to the full Senate with the recommendation that it do pass favorably be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator King? Senator Hagenbu?
Aye.
6 ayes, no nays.
Senator Hagenbu, you ready? Okay. Do this quick. Excuse me, there be 6 ayes and 0 nays. The committee substitute for Senate Bill 1667 will be reported to the full Senate with a favorable recommendation.
Thank you, Mr. Chairman and members.
Do you wish to go local? Senator Hinojosa moves that this bill be recommended for local and uncontested calendars. Any objection? Hearing none. So ordered. I recognize Senate Bill 2180 by Senator Hagenbuth. The chair sends up the committee substitute for Senate Bill 2180. Is there any objection to adopting the committee substitute for Senate Bill 2180? Hearing none, so ordered. I recognize Senator Hagenbuth to explain the bill.
Thank you, Mr. Chairman. Members, committee substitute for Senate Bill 2180 creates a certification requirement for peace officers conducting polygraph examinations in Texas. Right now, Texas law permits officers to administer these tests without consistent training or testing requirements. That can sometimes be problematic because polygraphs are frequently used in pre-employment screening, criminal investigations, and TCOL, Texas Commission for Law Enforcement, believes standardized regulations would help law enforcement better use polygraph technology and ensure that the consistent level of expertise and authorization is applied. The committee sub for SB 2180 authorizes the Texas Commission on Law Enforcement to develop rules establishing minimum training, testing, and certification requirements for officers conducting these exams. The substitute removes language that requires peace officers to be certified to conduct polygraph examinations for post-conviction sex offender treatment. That specific type of examination is a function of treatment and not a law enforcement role. So there is a joint polygraph committee on offender testing that sets guidelines and continuing education standards for sex offender treatment. In short, this committee sub for Senate Bill 2180 will help law enforcement maintain public trust by ensuring the polygraphs are administered by professionals meet clear, consistent standards, and respectfully ask that you support this common sense bill. I also have here today Bobby Rachel, President of the Texas Association of Law Enforcement Polygraph Investigators, Greg Stevens, the Executive Director of Texas Commission for Law Enforcement, and Lieutenant Colonel Walt Goodson, Deputy Director of the Law Enforcement Services for DPS, if the committee has any questions.
Any questions, members? Any questions? If not, we'll open this testimony. So the chair now opens it for invited testimony, and the chair calls Walt Goodson, Greg Stevens, and Bobby Rachel. Colonel, we'll begin with you. And you know, name, who you represent, and
Mr. Chairman, committee members, good morning. My name is Walt Goodson, Lieutenant Colonel with the Texas Department of Public Safety.
I'm Greg Stevens. I'm the Executive Director with the Texas Commission on Law Enforcement.
I'm Bobby Rachel, the President of the Texas Association of Law Enforcement Polygraph Investigators and an elected constable.
any questions for our witnesses? Senator Hagenboom? Senator Hagenboom, you recognize.
Senator Colonel List, maybe you could just explain a little bit about why you think this is necessary.
Yes, sir. So, the Department of Public Safety has a very robust polygraph program. We have 17 examiners. We administer a little over 2,000 polygraphs a year. A majority of those are pre-employments. As a result of those pre-employments, just in the past year, we've referred 31 of those for criminal investigation. We have a lot of bad actors that try to infiltrate the agency. We feel that polygraphs are a very vital tool in safeguarding our agency from undesirable candidates for the position of trooper trainee and police communication operators. On the criminal front, we do about 500 criminal exams a year. A majority of those are for external agencies, our state level and local partners. Overwhelming majority of those are sexual assault cases. Most of those involve crimes against children. We get about 40% confession rate from those crimes and have a very high clearance of those crimes where there would otherwise not be good evidence in those cases. We also, in 2024, identified 35 additional child victims of sexual assault crimes through those exams. The department has recently noticed since 2021, when the Polygraph Act was removed from TDLR, an erosion in the overall training of examiners, meaning less examiners are going to training. That specifically has manifested itself in more district attorneys reaching out to the department directly for quality assurance reviews of tests that are administered by examiners that are not of our agency. So we're concerned about the trust of those exams that are being administered, and they're very vital exams.
Thank you. Thank you all for your service, too.
Senator Parker.
Thank you, Mr. Chairman. Colonel Goodson, thank you for being here. Thank all of you for being here. Very much appreciate it. Just in terms of the number of men and women we have today within DPS that are specialists here in the polygraph, can you just kind of educate us on the number of folks that have had that specific training? I just want to shed some light on that.
Correct. Currently we have 17 polygraph examiners. Those are full-time dedicated polygraph examiners, not counting myself, who's polygraph trained and a former examiners, but those are the men and women that are doing the work each and every day across the state. And they did the tests I previously mentioned. I'll also mention the department has one of less than a handful of law enforcement polygraph schools, and they do training. In fact, we've trained officers from most states around the United States as well as all over the world. And it keeps our examiners sharp because they're heavily involved in that training process for other polygraph examiners around the state and around the country.
It's excellent. And just for folks that come in, can you bring in someone into the academy, become a new DPS officer, and then you start that training immediately? What is the duration of that? Just kind of give us a sense of that. I'm curious.
Right. So polygraph school is 400 hours. It's a 10-week school, and then there's a FTO, so to speak, process after that, where you'll generally run about 30 exams. There used to be a requirement that you had to run a minimum of 30 exams under the guidance of a experienced polygraph examiner, but that's the general rule. They'll usually work with someone or partner with someone for that first year. To back up a little bit, generally troopers in our agency are not polygraph examiners. When you promote into CID as a special agent, that's your first opportunity to enter the polygraph program and go to polygraph school and become polygraph trained.
Thank you for educating us. Thank you very much. Appreciate all that you do.
Thank you. Any questions or any comments? None? Well, thank you very much. Thank you for your testimony. Thank you for being here, Colonel.
Thank you.
Invited testimony is now closed. Chair now opens for public testimony. Chair calls Michael Mitchell and J. Patrick O'Burke. So we'll start on my right, and we state your name, who you represent, and your position on the bill. You have 2 minutes. Thank you.
James Patrick O'Burke. I'm with the Polygraph Institute in San Antonio. I'm here and testifying in opposition to the bill the way it's currently drafted. I would say that I'm a very strong supporter of polygraph licensing and accreditation. I run a polygraph school. I'm the only course provider for post-conviction sex offender testing, past president of the American Polygraph Association, member of the American Academy of Forensic Science, and I do polygraph research. The issues that I see with the bill is that it limits it to police officers or peace officers only. There's a substantial number of private examiners who are forced to provide polygraph services for 60% of the agencies that are less than 10 in number, and they can't possibly provide for polygraph or the training that's necessary. So relying on a private examiner places them in a significant disadvantage, particularly where they were using an examiner who's not licensed, and this agency seeks to have accreditation and other issues. So I have a concern with that. I'm concerned as well about the inclusion of PSOT, which was designed to be a completely separate function from peace officer licensing. So I was opposed to the way the bill is worded and hope to see that it included private examiners as well who provide services.
Thank you. Thank you for your testimony, Mr. Mitchell.
I am Michael Mitchell, a private polygraph examiner, here to testify against SB 2180 as written. As a private polygraph examiner with 1,200 training hours, a member of two state, 3 national, and 1 international polygraph organizations, I'm also a certified forensic law enforcement polygraph examiner. But I'm also a retired master peace officer with over 4,200 peace officer training hours. And although it seemingly has good intent, the proposed bill has too narrow a scope. The polygraph industry has a significant role to play in public safety. Regulation, continuing education, and licensing are all important. We had it in Texas until sunsetted about 4 years ago. In fact, I am the last in-state licensed polygraph examiner in Texas, and I welcome back oversight. However, not as written in this current bill. It's solely focused upon current commissioned peace officers. Many police agencies are too small to have their own polygraph examiners and rely upon contractors like me to provide them with services. I also conduct numerous post-conviction sex offender polygraphs annually for therapists and probation officers. I do this in the interest of public safety. But the proposed bill as written is myopic. Please do not pass it as written. Cover all examiners. Please craft a bill for all of us in this industry, retired officers like me, retired federal agents, to name a few. Have our industry regulated by a parent organization that can appropriately regulate all of us in Texas. I'm very active, and I appreciate your time.
Senator Hagenbu.
Yes, gentlemen. I'm sorry, didn't get your name, sir.
Mitchell.
Michael. Mitchell, yeah. So you're saying you agree that there should be a standard set.
Love it.
And you would agree within that standard that peace officers should be included. Your only concern is that you'd like additional people to be included.
Yes, sir. This bill feels to me like it carves out 17 DPS polygraph.
Well, to me, then that sounds like at least we're getting partway there. That we're at least including some portion. Wouldn't disagree with that. In terms
I do
of the bill.
disagree, sir, because it bifurcates the industry and it creates confusion for my clients, the smaller police agencies.
Understand. Another way to look at those, we're getting some that are certified. We come back later potentially and look at more, but at least this bill is getting some. But appreciate your testimony. Yeah.
Thank you. Any other questions, members? Thank you all very much for being here. So seeing that there's no one else registered for public testimony, is there anyone here that wishes to testify on, for, or against Senate Bill 2180? Hearing none, public testimony is closed. So the chair moves that Senate Bill 2180 do not pass, but that the committee substitute for Senate Bill 2180 be adopted in lieu thereof and be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles. Senator King. Senator Hagenbu.
Aye.
5 ayes, no nays.
There be 5 ayes and no nays. Committee substitute for Senate Bill 2180 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu, do you wish this bill to be recommended for local and uncontested? Senator Parker recommends that committee substitute for Senate Bill 2180 be recommended for local and uncontested calendar. Is there objection? Hearing none. So ordered. Ready to do yours? Okay, so we want to reopen your Sunset Bill 2405?
Yeah, I don't know if you open it up or just the.
I'm just going to send it up and pull it down. Yep. Send it down, send it up and pull it down. That's all I got to do. Yeah. No. Yeah, I already talked to Karina. It's good.
Chair recognizes Senator Huffman.
Thank you. In regards to Senator Parker's committee substitute, Senate Bill number 2405, which is the Sunset TDCJ bill, at this point in time, I would offer up a committee amendment. Members, you all have copies of that. I'm just putting it out there so that it will be eligible for consideration on the floor. I will pull it down at this time, not ask the committee to vote on it, just qualifying it for the floor purposes. With that, that's all I have.
Members, any objection? If that's so ordered.
Thank you.
Thank you, Senator.
It's hard to just. I'll explain to you.
Yes.
Yeah, it's just, it's
Can you lay-
to do with this roll call.
Can you lay it out, but it has to be the off? So the chair recalls a committee substitute for Senate Bill 2405 for consideration. So the chair moves that Senate Bill 2405 do not pass, but the committee substitute for Senate Bill 2405 be adopted in lieu thereof, be reported to the full Senate with a recommendation that it do pass favorably, and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Aye. Senator Miles? Senator King? Senator Hagenbu?
Aye.
5 ayes, no nays.
Be 5 ayes and no nays. Committee substitute for Senate Bill 2405 will be reported to the full Senate with a favorable recommendation. That one will go to the floor? And that one will go to the floor. So ordered. Chair lays out Senate Bill 1506. The chair sends up the committee substitute for Senate Bill 1506. Is there any objection to adopting the committee substitute for Senate Bill 1506? Hearing none, so ordered. Recognize Senator Parker to explain the bill and the committee substitute.
Well, thank you, Chairman Flores and members. Appreciate the opportunity to come before you here this morning with the committee substitute for Senate Bill 1506. Texas law currently requires the Board of Pardons and Paroles to reconsider parole-eligible offenders every year in many cases, even when there is little to no likelihood of release. This system places an unnecessary and very painful burden on victims and their families, who must repeatedly relive their trauma by traveling, sometimes long distances, to testify against an offender's release. It forces them to endure the emotional toll of preparing for and attending hearings year after year, with no certainty of when the process will end. And furthermore, the current one-year review cycle is also unfair to incarcerated individuals. Many offenders face annual parole reviews with no realistic chance of release, creating false hope and an endless cycle of disappointment. Additionally, continually being up for review prevents inmates from participating in certain programs that would aid in their rehabilitation. This committee's substitute for 1506 addresses these issues by giving the Board of Pardon and Paroles the ability to extend most hearings out up to 5 years rather than the currently required one-year extension. We believe the benefits of this will be to reduce the burden on victims, it will increase efficiency for the parole board, and it will also maintain oversight. The committee substitute clarifies that 1506 applies to inmates that are currently incarcerated, not just future inmates. And this was always the intention, and this language simply makes the applicability more clear. And with that, Mr. Chairman, I'm happy to answer any questions and proceed with testimony. But thank you so much for the chance to lay out the bill here.
Senator Hinojosa, you recognize.
Yeah, thank you, Mr. Chairman. And I guess what the bill does, it does provide the discretion to the Board of Pardon and Paroles for up to 5 years.
Yes, that's correct. I mean, you just see these victims and what they've had to go through for so many years.
I understand that, but they're not locked in to 1 year like they are right now.
That's correct.
All right, thank you. That's a good bill.
Thank you, Senator Hagenbu.
Thank you, Mr. Chairman. Just to follow up on that question. So they could set it for, say, 2 years or 3 years, depending on their discretion, the parole board's discretion, or up to 5, but anything in there, right?
That's correct. Again, we're just trying to, I mean, I'd love to see as many cases as possible go to 5 years. We're trying to provide some discretion. But again, I just think the current 1 year standard is very painful and unnecessarily so for victims and their families.
Appreciate it. Good bill. Thank you.
Thank you.
Thank you. Seeing the chair now opens up for invited testimony. Chair calls Marsha Moberly and Jean Turner. Jean Turner. We'll begin on my right. Please state your name, who you represent. Ms. Turner.
Good morning, Chairman and members. My name is Jeannie Paul Turner. You want me to go ahead with my testimony?
Please.
Okay. I'm not sure I can do justice to this event in 2 minutes, but I'm certainly going to try because I know your time is so valuable. I may read it just to help me with my nervousness. It's good to see some faces that I know. I'm a victim, but I'm a survivor. I felt I was safe in my own home with my family, and that was most definitely not true. We had an alarm system, we had good locks, and we thought we were careful. This man had watched my home for days since he had just been released from prison for the second time and was living in a halfway house. There were 28 victims, and I was the first one. I was kidnapped and taken out of my home. My life changed in 1984 forever. I was always afraid. The trial was torture. They didn't catch him right away, so I had to wait and hope that they did catch him. And every 2 years, I had to go back and testify to the parole board. Basically, I would get the information after I testified, and they would say, "We're just getting you prepared for the next testimony." So it was never out of my mind. I did this for 40 years. I will be 78 this month, and I did this for 40 years. And I did this so that there will be no more victims, because if I didn't keep this man in prison, then there would be more victims, because with my case, this was the third time that he was going to prison. God was with me every moment that this event happened. The experience was beyond believable. I convinced him not to rape me and murder me as he said he was going to do. I jumped out of a vehicle going 30 miles an hour, and back then I could bounce no more. My life matters, but so do all the lives of victims of crimes. Please extend the time that these people come up for parole to 5 years. I'm begging you, because what it does is it affects your entire life, and you're never the same, and you never get over it. And if you think that you do, you're wrong. Experience it. With a knife and a .357 at my side and at my throat, I truly believed that I was going to die. Talking about mental health, it's a little bit difficult to maintain when you know that you've been through what I've been through. And I just ask of you that please consider taking care of this. If you've been in prison 3 times, if you've been in prison 2 times, I'm not sure what you really deserve. But I was in prison as well with him. Thank you so much.
Thank you for your testimony, and sorry for what you had to go through, but thank you for being here and telling your story and helping us in making our decision-making. Thank you.
Thank you.
Senator Parker.
Jeannie Paul, thank you for being here. Some of you, my colleagues here, know that we're dear friends, and you're my first grade teacher. And so we've maintained a relationship all these years. And you're an incredible hero, all that you do for all the kids in this state over the years, all you've done for the retired teachers. And all the years that we knew one another, you never talked about this. You took all this on yourself privately and never talked about it. All the 40 years of hell that you've gone through. And I want to tell you that we love you, and we're going to pass this legislation to protect you and all the other victims in this state that have gone through such horrific things. It should never have happened. And thank you for your courage. Thank you for coming forward, and for all you do, and for who you are. And I couldn't have been more blessed in life to have a more wonderful first grade teacher. So thank you, Jeannie Paul, for being here and your beautiful testimony. Thank you. Thank you.
Members?
Good morning. My name is Marcia Mobberly. I'm chair of the Texas Board of Pardons and Paroles. I represent the agency, and I am neutral and here as a resource. The Board of Pardons and Paroles sees many positives on this bill, as presented by the author, Vice Chair Parker. This bill provides the parole board with the discretion or the ability to set the next parole review, or what is called a set-off, up to 5 years. By allowing this, we see benefits. By giving the board the discretion to set off longer than 1 year, if exercised, this would not require a victim to appear annually in front of our board and our parole commissioners. We understand the trauma and anxiety that goes with coming into our office and speaking with our board, and we hope to minimize the number of victims that must appear before us and the number of times a victim must appear. This would also provide for offenders and their families to have clear notice of when they may come up for review. We receive complaints about an offender being continually denied annually over many years. If the board has the discretion to give a multi-year set-off, this would allow offenders to have a clear understanding of what they need and what they need to work on between that time we reviewed and the next period. By having the discretion to multi-year set-off, we anticipate that this will decrease the numbers of annual parole reviews, and it would allow better efficiency for our board. We have conducted yearly last year, about 66,000 parole reviews. Of these reviews, 4,500 involved a third consecutive parole review. Let me share one case with you. In 1989, there was a intox manslaughter case that happened in Bront, Texas. Brock, Texas, in Parker County. And it killed 4 individuals, 4 high school students. It happened during the holidays. The girls were coming back from a Christmas basketball game. All 4 of the girls were honor students. 2 of the girls were cheerleaders. All of them were very involved in their very small school district. This offender was sentenced on these crimes in the year 2000, and he had nearly every review yearly for 20 years. He served his entire sentence, and this is the type of case that this would impact, along with this case. Let me also make it clear, we do not see this as adding to the amount of time an individual serves. The board still will have the discretion to approve an individual for release, or if denied, still impose a 1-year set-off. It is simply another tool to be used. In closing, I would state that in our self-evaluation report to the Texas Sunset Commission, we included this as a recommendation. Thank you very much for bringing this.
Thank you, Senator Parker. You're recognized.
Thank you, Mr. Chairman. Well, thank you for that excellent explanation of structurally how it would work and the number of cases and the impact it could have for all these families and that have suffered all these victims. And again, I think you pointed out the balance that the benefit to the offender as well. So thank you for that. Thank you for all you do for Texas every day. Very grateful. Thank you for the support as well during the sunset process and of this concept being something that you all strongly support in the recommendation. So thank you very much.
Thank you. Senator Huffman?
Yes, thank you. And I wanted, what is her name?
Jeannie Paul.
Jeannie, I just want to say thank you for being here. And I want to point out to the members that sometimes we get bills and issues, and we're supposed to think that something that happened 40 years ago doesn't still hurt. But I've been watching you, and this has still affected you all these years, and it's still just a part of your life and a part of who you are now. So members, never forget that decades can pass, but a lot of times the victims are serving life sentences too. Thank you for being here and reminding of us of that.
Thank you.
Thank you.
We love you. Thank you, Jeannie.
Thank you.
Thank you.
Thank you for being here. Are there no other invited witnesses? Invited testimony is now closed. Public testimony is now open. Chair calls Shannon Dion. Shannon Dion. Thank you for being here. Please state your name and who you represent and your position on the bill. You have 2 minutes.
I'm Shannon Gleason Dion, representing myself in support of SB 1506. That was incredibly compelling testimony. I'm just going to add to it. Thank you all for this opportunity to hear our family story, and thank you, Vice Chair Parker, for filing this very important bill. I want to start off by being clear, I do not challenge the right to parole review. What I challenge is the custom of once a set-off is 1 year, it remains. This gives the deciding commissioner the reach to determine future set-offs. In 1989, Glenn Anthony, a violent repeat offender with no remorse, was sentenced to 99 years for kidnapping, robbing, and brutally raping my sister, Nancy Gleason Taylor, which was all premeditated. After just 15 years into his sentence in 2003, he was eligible for parole due to prison overcrowding. Nancy died of pancreatic cancer 1 month later. Parole was denied that year and again in 2011 and 2016. In 2016, we were shocked. The set-off was 1 year. I assumed the next set-off would be longer, as it had been in the past, unaware of the 1 year set-off custom. It's not really 1 year for the victim and family. Notification of a review comes months before the review, forcing us to relive the trauma of Nancy's crime every 6 months. In 2016, 17, 18, 19, 20, 21, 22, and 23, we have had to share painful details of Nancy's suffering over and over. How she was forced on her knees in a field, a gun to her head as she prayed that her death wouldn't hurt. We recall my mother's collapse when we heard Nancy had been seen driving away with a man sitting behind her in her car. We remember sitting in the courtroom, listening to Nancy on the stand recount the horrific sexual assault, fearing she would die. This criminal has been denied parole as he poses a continuing threat to public safety. His set-off should be based on the facts of the case, not a custom that forces family victims into
Please continue.
continuous anguish. Today, you have the power to end this cycle of torment for victims and their loved ones. Please take action to protect us from this cruel treatment. Thank you so much.
Thank you. Senator Parker?
Thank you, Mr. Chairman. Shannon, thank you for being here. And we're so sorry for all that your family endured and your sister suffered through. And I appreciate you sharing the story so more people understand just how egregious this is and why it needs to be addressed and changed. So thank you very much for being here.
Thank you, sir.
Thank you for being here.
God bless you.
Chair sees no one else signed up for public testimony. Is there anyone here present which to testify on, for, or against Senate Bill 1506? Hearing none, public testimony is closed. Chair moves that Senate Bill 1506 do not pass, but that the committee substitute for Senate Bill 1506 be adopted in lieu thereof, be reported to the full Senate with a recommendation that it do pass favorably and be printed. Senator Parker, do you have a statement? And be printed.
Mr. Chairman, quick question.
Senator Hagenbu.
Small question, but this is a wonderful bill, and obviously appreciate the testimony and the folks going through this and how much this will help these victims. You had a bill earlier that had a great outcome, but there was a side benefit of efficiencies, of savings of $150 million, I believe. This sounds like there could be savings with it too, in terms of less hearings, the thousands that they have. It sounds like there's maybe an efficiency opportunity here as well.
Yeah, Senator, perhaps we've not looked to see what that would look like financially, but yes, it's possible there could be some. We can visit with the agency about whether or not there would in fact be any scorable savings, but yes, good point.
Appreciate it.
In addition, just another value,
Thank you, Mr.
valuable
Chairman.
add to the bill.
Senator Parker, do you have?
No, I just appreciate, Mr. Chairman, you and the members hearing this very important piece of legislation today and helping us take action on behalf of the people of Texas.
Clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman? Senator Miles? Senator King? Senator Hagenbu?
Aye.
5 ayes, no nays.
5 ayes, no nays. Committee substitute for Senate Bill 1506 will be reported to the full Senate with a favorable recommendation. Mr. Senator Parker, do you wish to be recommended for local and uncontested?
Yes.
Senator Hinojosa recommends that the committee substitute for Senate Bill 1506 be recommended for local and uncontested calendar. Is there objection? Hearing none, so ordered. Senator Huffman, ready for 1124?
Sure.
We're going to go ahead and call it out. Chair lays out Senate Bill 1124 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, when the legislature passed the Michael Morton Act in 2013 to revise criminal discovery, it used the term "the state" in a manner that blurs the role of the prosecutor and the investigator or agencies in providing discovery to the defense. As a result of this ambiguity, the Texas Court of Criminal Appeals in June 2024 held in State v. Heath that a trial court may suppress relevant and incriminating evidence of a defendant's guilt for failing to disclose it upon request, even when a prosecutor had no knowledge that the evidence existed at the time of the initial request. This ruling applies even when the prosecutor acted in good faith and the defendant suffered no prejudice from the non-disclosure. Unfortunately, defense lawyers are now taking advantage of this technicality by not specifically requesting evidence that they know a law enforcement agency has failed to turn over to the prosecutor. Then at trial, the defense can invoke Heath to have it excluded. This gamesmanship undermines the integrity of the trial process and the core principles of justice. Senate Bill 1124 seeks to rectify the unintended consequences of the Heath decision, which permits the suppression of inculpatory evidence without requiring a showing of bad faith by the state or harm to the defense. Members, this bill does not apply to exculpatory, impeaching, or mitigating evidence benefiting a defendant, nor does it prevent a court from suppressing evidence in cases of bad faith by the state or incurable prejudice to the defense. The bill clarifies the definition of the state, quote unquote, for discovery purposes, distinguishing the responsibility of prosecutors from those of law enforcement agencies. The bill also establishes new procedures for requesting discovery, empowers courts to limit overly broad discovery requests, and codifies pre-Heath common law standards governing the suppression of evidence. I'd like to thank the elected prosecutors for working on this legislation with my office, helping make certain that the Michael Morton Act is being preserved and implemented as intended. This change will ensure that our criminal justice system is weighted equally for both victims and the accused. That's it.
Members, any questions? Senator Hinojosa?
Thank you, Mr. Chairman. Just a couple of questions, Senator Huffman.
Yes.
From the Heath case that you discussed and talked about. In that case, there was an issue about who represented the state, the police or the prosecution.
Correct.
The DA. And it clarified that both represent the state. But in those type of situations where police officer withholds evidence that may be exculpatory.
Right.
How do we encourage the police officer to release that information if they just withhold it, and then there's no way that the criminal defense attorney knows about it?
Well, I will say that this bill does not touch at all the current law that would apply to that situation where exculpatory evidence that was deliberately withheld. Clearly, the law is very clear on that, and this bill does not address that nor change current law or what's being practiced in the courts or the responsibilities of law enforcement and the state as it regards that.
And I know that's your intent, but I guess I don't see it in the body of the bill. So it might be a good thing to just add that language that it does not include exculpatory.
I think if you look at it, and of course there are prosecutors here that I'll let them specifically address that because we have discussed that, and it's not the intent of the bill, nor will it change common practice. If we think it will, we'll fix it, but I would like the prosecutors that are here as invited testimony.
Well, and we should work on that. I really, I know what the intent is, but I just want to make it clearer. The other issue has to do with it seems like we're changing some of the wording and usage that we use in the present legislation on the Morton Act to sort of narrow the discovery which can be provided to a defense attorney. Is that your intention?
I don't think that's the intent. Again, this is going towards inculpatory evidence that perhaps had been in the knowledge of the law enforcement, but the prosecutors didn't necessarily have it. And again, sometimes tactics are used to try to, suppress that evidence by the defense at the last minute. But again, the prosecutors can address those specific issues and give you examples of that.
And one more question, and that is, right now under present law, we created a portal so that all the evidence could be placed in the portal and available to both the prosecution and defense attorney. Mm-hmm. But now you have in your bill certain, I don't want to call it restrictions, but I guess guardrails, if you will, on some of the evidence that may not be relevant. How will we go about dealing with that issue? I guess I'm
not sure I understand your question. Yeah.
My question, I guess, is what impact would this bill have on the portal, the lab portal? It seems to me that right now we passed legislation to make sure that the portal was not caught in the middle of any disputes between the prosecution and defense attorney. And the way the bill is written, it would seem to me that if the judge is going to limit evidence or requests that are overly broad, how will that impact the use of the portal?
I don't think it impacts it, but again, we'll ask the process. I don't believe it's intent to impact it or what the rules are. I think it's just clarifying when the evidence can be placed, and if it's not, whether it affects what's admissible. But again, I'd rather the prosecutors.
No, and then we have Brett Mills also here from DPS that works on that issue.
Okay.
But I also have a suggestion on that might help clarify that. If I
We'll
may.
always look at what you might offer, and then we'll see what we think.
Thank you, Madam Chair.
Okay, sure.
Any other questions? Other questions? Chair now opens for invited testimony. Chair calls Brett Ligon, Sean Dick, and Brian Middleton.
We have a bipartisan panel here, Mr. Chairman. So that was the intent here.
We'll begin to my right. If you'll state your name, we represent, and you may proceed.
Good morning, sir. My name is Brett Ligon. I'm the District Attorney in Montgomery County, Texas. I've been the elected district attorney for the last 17 years. I believe that perhaps I may be up here because I was one of the few elected district attorneys that was in the room when Michael Morton was promulgated. And Michael Morton is a beautiful man. His story is so important and impactful. And maybe it's because Easter's on me, but I am reminded that Jesus wept at the tomb of Lazarus. And every prosecutor in that room wept. And it's our worst nightmare to think that an innocent man would spend time in prison. And 3914, which was promulgated as part of it, is a beautiful effort, but it's like a child, it's clumsy. We were told at the time that 3914 would be fixed, it would be refined, it would reflect the search for truth. When Michael Morton visited this august body, Senator, you and I have practiced together, this body, and he said his search was for the truth because he was denied the truth. Because Williamson County, Sean Dick is now the elected DA there. Williamson County had this archaic policy called a closed file policy. The only DA's office in the state that was practicing it. It kept Michael Morton from knowing the truth. It kept evidence from him that the state knew about, but they wouldn't test it. But y'all didn't stop there. Y'all then promulgated another rule, Chapter 64, that would specifically allow testing. It's been fixed over and over and over and over. What Senator Huffman's bill does is deal with one particular issue. It's the suppression of evidence. Think about evidence, right? Our job, we have the best duty. We're the only people in this whole building that have a sworn duty to seek justice. And seeking justice means finding the truth. And you can't have the truth if you have partisan judges who have their own agendas deny the jury the opportunity to see truth. The Heath case had nothing to do with truth. Separate the man from the mechanics of discovery. Michael Morton is an inspiration. It inspires all of us. You'll hear Jarvis Parsons, the elected DA in Brazos County, talk about how we all embrace it. We bought the book, we shook the man's hand, we preach it because we want it. But these mechanics are flawed. Criminal law is supposed to be about the search for the truth. A suppression by itself is oppressive. It's aligned with terms like fruit of the poisonous tree, prejudice, and harm to a defendant. Heath erased all that. Senator Huffman seeks to restore that. It deals with the suppression issues that say, wait a minute, Judge, before you toss evidence, you've got to show some malignancy on the part of the prosecutors. You have to show some prejudice to the state. And by the way, adopt a remedy that the court in Heath said that the legislature should be doing. Texas Court of Criminal Appeals Justice Newell asks you to interpret his words. It's in Heath, written there, and he says the legislature can come and do this. And that's what we're doing. So the Texas Court of Criminal Appeals punts it to y'all and says, hey, do something about this, define it. Senator Huffman has offered up a bill. My cohorts are going to do an incredible job. And please point out, purple, blue, red. Yeah. Red. This is a very bipartisan effort to show and to demonstrate how discovery gets to the truth. Thank you, Senator Huffman, for this bill.
Trying.
Thank you. Good to see you.
Purple. Good to see you, Mr. Chair. So next time I won't make the mistake of sitting next to Mr. Ligon. I'll sit next to Mr. Middleton on the other side. My name is Sean Dick. I am the District Attorney of Williamson County. I realize the irony in that the Michael Morton legislation came out of our county. But I believe very strongly in that legislation. I think it was a very good change to the law. I happen to be a defense lawyer at the time that case was going through the courts. And I watched it very closely. I was actually an attorney associated with that case. So I know the ins and outs, and I understand what the intentions were. Now back as the District Attorney of Williamson County, I'm starting my 8th year. And I've just seen that there are a lot of issues that the Michael Morton case didn't initially address. The biggest that I'm going to say is just the change in the amount and volume of evidence that comes to our offices. So we review about 3,500 felonies a year. And at any given time, we have 1.15 million pieces of digital evidence for 26 lawyers to look at. 1.15 million pieces of evidence. Now, that might be a piece of paper. It might be an entire video, audio, cell phone dump. But there's 1.15 million pieces for us to look at, and we want to give over 1.15 million pieces to the defense lawyers. The problem is, with the volume of evidence that we're dealing with, sometimes they're just going to be things that we don't catch right away. But somewhere down the line, we'll catch them. And so there's a burden that's put on our prosecutors where they feel like they're now just digital evidence managers. They're not attorneys. They're not prosecutors. They're busy handling digital evidence. We need some guardrails in place so that the judges can make some rulings and have some thoughts about how far this goes. To give you an example, I know sometimes people think the Heath decision is just a hypothetical, but we have defense lawyers that are poised to use it at the drop of a hat. I mean, 30 days after a case is filed, and keep in mind, we give discovery within 24 or 48 hours sometimes. But we have lawyers that are ready to file a Heath motion 60 days into the case being filed. And in fact, we had an indecency with a child by sexual contact, indecency by contact case involving 4 children under the age of 14. And while the case was pending, it gets set for trial. The prosecutor realizes the police had the defendant's cell phone in their custody. They worked with the law enforcement agency. They got a search warrant. The judge signed the search warrant. And guess what we found on his cell phone? All sorts of child porn. And not only did the child porn corroborate the testimony of these children, but the child porn actually could lead to additional charges and in fact included pictures of the children themselves. We had a visiting judge come hear a Heath motion and said, well, it just took too long. It sat in the police custody for too long. I'm going to go ahead and grant a continuance, but I'm going to suppress that evidence forever and ever. So we have evidence of child porn in a child abuse case that will forever be not usable simply because a visiting judge decided, based on the Heath decision, that he could do it. And so we're asking that there has to be some findings, there has to be some rules put in place so that the truth does come out and we as prosecutors can follow our duty to see that justice is done. So thank you, Senator Huffman, for filing this. And thank you, Mr. Chair. So appreciate it.
Thank you.
Thank you. I am the blue one, as I indicated. And I'm here testifying in favor of Senate Bill 1124. I think I'm the only one of the 3 that's also a certified police officer. I support law enforcement. And one of the things that I'm keenly aware of is that I don't have direct supervision of police officers. We had an experience in Fort Bend County where we were trying a murder case, and from the witness stand, we found out that there was additional body cam. Now, we have good judges in Fort Bend County. We did not have that evidence suppressed, but we had no knowledge of these other body cams. We do our best to make sure that we obtain all the evidence and turn it over, but not having direct supervision of police officers can lead to unintentional evidence not being turned over. And Heath, I think, went way too far, made it a strict liability If you violate, if you don't turn it over timely, then it's a violation of the statute. And then said, you know, it's up to the court's discretion whether or not to suppress it. Well, I think 1124 fixes that problem and requires that there be some finding of bad faith. And what I encourage you to consider is that what we have to remember, and we heard the witness testifying earlier, that we speak for the victims. And so when we have evidence excluded, there may be a denial of justice just because one judge decided that without a finding of bad faith and no intention of excluding evidence, that evidence was excluded. I think that price is too high. I think our citizens deserve more. I think the victims deserve more. And I think we ought to be able to try our cases based upon all the evidence and not have excluded where there has not been a finding of bad faith. So I encourage you to pass this legislation and protect victims and protect justice in Texas.
Well, thank you all for being here. Any questions, members? Senator Huffman, you like?
No, I don't. I'm sorry, my light's just.
Senator Hinojosa?
With the blue.
Yes, sir.
You know, and I agree. I mean, it's a big issue and a big problem when police officers don't turn over the evidence, and quite frankly, the DA is not aware of it. In the Heath case, that I don't necessarily agree with the decision the way it was made, but you talk about good faith or bad faith. How do we end up dealing with that issue when there's evidence that's being withheld, and all of a sudden it comes forward after during the trial? Like when you were asking questions of the witness, all of a sudden you find out there's another video available, camera. How do you deal with that issue and the problems there?
Typically, in my experience, the way it's been handled, there's a hearing that's conducted to determine, what caused the evidence not to be turned over. And prosecutors are put on the witness stand, police officers, everyone. So there's a fact-finding to determine what caused the failure. And so then that's how we make a finding. And what this bill does is require that there be a finding.
And if the finding shows that there was not done in good faith, it was something just inadvertently done, then it would be that the evidence come in against the defendant.
Yeah, or remedied by continuance, whatever it is that's necessary to allow the defendant to have a fair trial. But we already have in place remedies for these different type of situations, but he took some of those away. And to address your concerns about Brady, there are numerous laws, there's constitutional law that requires us to turn over exculpatory evidence. And failure to do it can cause you to lose your license. So your concern about exculpatory evidence, I think, is covered even under state bar rules. So I don't think this Senate Bill 1124 creates any problems in terms or jeopardizes exculpatory evidence not being turned over, because I can tell you that's a heavy burden for all of us that we take very seriously, because the three of us can lose our license if that occurs.
Yeah, the DA for Williamson County at that time lost his license. One more question. That's, I guess, so if you find that the evidence was withheld in bad faith, not necessarily by DA, but by the police officer, could the evidence still be suppressed?
I think, yeah, the judge under this proposed statute, Senate Bill 1124, I think the judge would then have the discretion to exclude it because the police officer is part of the state. So if they found out that the police officer intentionally did it, then that would be bad faith and could be taken into consideration. Another thing I wanted to add is that I spent 16 years as a defense lawyer, so I've seen both sides, and I just like Mr. Ligon pointed out, I mean, we all appreciate and respect the Michael Morton Act and the need for it, and we all want to, seek justice. And so I think this puts us back where we need to be, to where we're able to try cases and not have some judge with an agenda exclude evidence. So I think this goes a long way in protecting justice. So, thank you.
And just one more question, and that is, if I may. You spoke about being overwhelmed with digital evidence. And but who will make the decision of whether or not certain evidence is relevant to the defense?
So, for example, in Montgomery County, we've gone to a paperless discovery system. So one of the portals that you were referencing, the defense bar has a portal. So we're under a continuing obligation under the Michael Morton Act, specifically 3914. So even after the case is over, we're still required, when we become aware of evidence, for example, lab reports, it happens all the time. We'll get a lab report after the defendant has already pled guilty with the assumption that the defendant knew what he had, correct? And so we'll have to disclose those. Sometimes the amount may change, sometimes the drug itself may change. But the discovery requirements oftentimes from a judge are very articulated. One of the issues in Heath was the guy says, can you give me the discovery? So in almost all criminal courts, the courts have a very specific discovery rule, and it sets out all the basics. Most defense attorneys have a supplement to that. And I think this might be the only panel in which I practiced 10 years as a criminal defense attorney. Sean Dick practiced over a decade as a criminal defense attorney, and Brian practiced 16 years. So you're talking about people who have done both that understand that the search for truth is better for everyone. So what goes into the system? 3914 tells us a bare bones minimum of what goes into the system, whether it's witness statements, video, I'm trying to think, other things. For example, grand jury testimony can't go into the system absent an order from the court. And so 3914 is a very robust rule as tells us right off the bat what we have to put into it. But I wanted to address your specific question. You asked about exculpatory evidence. Heath didn't even reduce that conversation as to whether or not the 911 call was exculpatory or inculpatory. Didn't even mention it. Just said, hey, suppressed. 3914H specifically says, notwithstanding any other provision, so regardless of what Senator Huffman's bill seeks to clarify in regards to suppression issues, H is still there, notwithstanding Senator Huffman. Any other provision of this article, the state shall disclose to the defendant any exculpatory evidence, impeachment, or mitigating document, right? And so we're already there. As Brian pointed out, we're subject to the state bar now. In 2013, the concern was raised between us and the defense bar, was this going to be used as a bar grievance issue? We were promised it wasn't, and now that it is. Even though the vast majority of non-disclosures, what are called inadvertent non-disclosure. In the particular case of Mr. Morton, the elected DA at the time lost his race. The DA that was handling the case not only lost his license, but went to jail. And so it's become something different in the sense that it is become weaponized. I don't believe that Michael Morton, who every time I ever spoke to the man, talked about the search for truth. He has no idea that he has been reduced to nothing more than a voodoo doll. They pulled him like a sword, and he has no idea that in court 1,000 times a day, his name is blasphemed. They say, I will pull a Michael Morton. I'll file a Michael Morton sanction against you. It's Michael Morton this, Michael Morton that. And I always think to myself, he's a real man. He's a real man. But those protections are already there, Senator.
Many times when we pass legislation here in the legislature, actually been in place for years, or you have different issues come up and bubble up, and then we try to come back and sort of address those issues. So I'm pretty much aware of some of the abuses that take place. When I filed for discovery, I asked for everything, including the kitchen sink, but I name it under the discovery rules, criminal statute. That is very important. Otherwise, you're out there left out without proper documentation. I'll pass the witness here.
Thank you. But thank you all for being here. Appreciate it.
Thank you. All was excellent. Thank you.
So members, we need to recess and reconvene after the session. Members, we have to go to the floor.